will serve
Yes,
the
in the court
amended
note,
copy of the written statement to the learned counsel for the plaintiff, as the defendant number 1 and 3 had already filed the written statement in the instant suit. Police. As the parties have already filed the defendants have already filed the written statement. Accordingly, the parties are directed to complete the discovery and inspection of the document within 3 weeks.
yes.
Full stop. Affidavit of
Lordship, the issues will also have to be framed.
affidavit of admission and denial of the document be filed within 2 weeks thereafter. Full stop. In the meantime, the parties are directed to exchange their suggested issues.
Grateful.
Full stop. List the matter.
Your Lordship, liberty to file the statement of
Already-
truth and
List the matter on 30th July 2025 for framing of issues.
I am grateful.
deeply obliged.
Thank you, sir.
Next.
Your Lordship, I appear on behalf of the defendant. Your Lordship,
Yes.
in terms of the last order, Lordship had directed the plaintiffs to comply with the Commercial Courts Act, provisions of the Commercial Court Act. However, Your Lordship, they have not complied as of yet. Your Lordship, we accordingly praying for dismissal
You are appearing for?
for the defendant.
Who is for the plaintiff?
Your Lordship,
You filed the written statement.
Your Lordship,
Have you filed the written statement?
Your Lordship, there was a delay, so we have filed a condonation of delay application which is pending. So we have served the written statement and Section 5 application to the defender to the plaintiffs. However, Your Lordship, the suit was transferred to the commercial division.
ये इसमें और इसमें नहीं है रिटर्न स्टेटमेंट ट्रुथ वगैरह नहीं है नहीं है yes you have filed an application GA number
GA number 3, Your Lordship. This is for condonation of delay.
condonation of delay of
How many days?
for what
For filing of written statement, Your Lordship.
when you receive the writ of summons January 2015
Yes, Your Lordship.
then
Your Lordship, in the meantime, the suit was transferred to commercial division, so they have
transferred to
to comply with the provisions. They have not, Your Lordship.
that is different thing 2015 the suit was filed now we are 2020-25 you not file the written statement you filed this application in 2024
Your Lordship, Order 7, Rule 11 was pending at that time,
maybe
which was disposed.
maybe 2000 my order 7 rule 11 order 12 rule 6 whatever the application what is the duty of the defendant has to file the written statement within 30 days and you have not taken an order from before the regular civil court for extension of now the commercial court how it can be
If Your Lordship may kindly grant a short passover, my senior is on his way to here.
master summon received on 31st of January it is admitted case your case is admitted then
But Your Lordship, in terms of since this matter has been transferred to commercial court, as soon as they file the comply with the provision, we will get a fresh timeline to.
no only you will also get the timeline for filing a statement of truth and filing list of documents nothing else After 10 years, the court cannot pass a new direction for issuance of writ of summons after transfer of the case in the commercial. You are appearing. If it not appearing, then the,
Your Lordship,
if
we
it-
are, Your Lordship, we have got the brief recently only. Your
you have filed that. Who has filed this?
This we have only
Then-
filed, Your Lordship, but if Your Lordship may kindly grant short passover.
Defendant, none appears on behalf of the plaintiff. Plaintiff, it is found from the record by an order. It's found from the record by an order dated 9th June 2025. This court has specifically directed the plaintiff to comply with the provisions of the Commercial Court Act by filing written statement and by filing
Your
statement of
Lordship,
truth, affidavit of documents and compliance and other compliances, failing which appropriate order will be passed. Today, when the matter is called, none appears on behalf of the plaintiff. No accommodation is sought for. From the record, it is found that the plaintiff has not taken any steps for filing statement of truth, affidavit of documents, and other compliance in compliance of the provisions of the Commercial Court Act after transfer of the suit from the regular division to this court. Considering the above, this court finds that the plaintiff is not interested to proceed with the matter as the plaintiff has not complied with the provisions of the Commercial Court Act. Accordingly, CS Com 5 of 2025 within bracket old CS 420 of 2014 is dismissed for default. Consequently, all applications are also dismissed.
obliged.
Next.
Your Lordship, I am deeply obliged.
Yes.
Wait, please, Your Lordship. Lord, I'm appearing for the defendant number 1 in the matter.
Hmm.
My Lord, GA4 is my petition.
Hmm.
My Lord, it's an Order 7, Rule 11 demurrer application, my Lord, which we have filed.
Huh?
My Lord, no affidavit to this has been filed. Point of law.
हम लोग का मत करो बोल दो कौन लागे उसको नहीं होगा बोल हम लोग का नहीं है
There's a injunction application by me, my suit, but claim is on account of not price of goods sold and delivered. It's a largely admitted claim. There are 5 defendants. Only one has filed a opposition. The others have not. So, Lord, as far as that is concerned, Lord, that injunction against them has to be confirmed. Nothing can be done. Now, realizing the difficulty, Lord, a Order 7, Rule 11 is then, Lord, brought to, Lord, avoid any further thing happening. This is the situation. Your Lordship will hear the Order 7, Rule 11. From what I've understood, Lord, none of the points my learned friends makes in the Order 7, Rule 11 can actually be decided under Order 7, Rule 11. My learned friend will satisfy Your Lordship because from what I can make out, they are all points of fact.
I'll not go into any facts, my Lord.
Let my learned friend make his submissions, my Lord. I'll deal with it on the next day, my Lord. Let my learned friend finish. I'll deal with it.
Very brief, my Lord. I'll indicate there are 2 pointers, my Lord.
you are
The Order 7
defendant number
My Lord, I'm
One.
appearing for defendant number 1.
yes
Short 2 points, my Lord, before I
GF4 दो
And since, my Lord, my learned senior my Lord, has not filed an opposition to this, my Lord, I'll take it that these facts which I've stated are uncontroverted. My Lord,
But
because
I
it goes not
understand
to
there were
find-
no directions. It's a point of
because,
law.
my Lord, on the
There's no
last
question.
day, we had my Lord, sought for this clarification. It was clarified that they don't want to,
Yes.
they don't intend to file an affidavit.
Yes, Lord.
So-
Order 7, Rule
so I'll
11
go
must
by
be on
those
the
facts
basis of
which
the
we have
plaint,
stated,
not
my Lord.
only.
Definitely, my Lord, I'll indicate.
That's without not admitting, not anything.
okay
My Lord, here, my first point, my Lord, I'll start with what is, my Lord, the brief fact. My Lord, it's not a simple money suit, which, my Lord, is being stated. That it's only a money suit, goods sold and delivered, and money not paid. That's not the case. Here, my Lord, it's an arrangement between the defendant number 1 company. So the other defendants are directors and they have a personal guarantee. That's a different issue. That's for them to defend. The defendant number 1 as a company, my Lord, placed orders on the plaintiff. Plaintiff, my Lord, entered into an arrangement that these goods will be exported from Singapore to India. We are in India. Plaintiffs, my Lord, are exporting those goods from Singapore. there's a clause. First, I want to indicate this, and I'm going to go with nothing other than the plaint, my lord. Nothing else I'll refer to. Kindly take up, my lord, the first volume of the plaint. Only two things I'll quickly indicate. Kindly take up page 5, my lord. Because after Dhanbad Fuels now and your lordship's decision in good faith holdings, my lord, 12A is my first point. And I'll indicate, because what is the urgency? I'll show there was no urgency. No pleading, and I'll show from the pleading. So that's my first point. And let them, my lord, pass and cover that point first. Kindly take up page 5 of the plaint, my lord, volume 1. It's 5B.
Yes.
5B. After receipt of the goods delivered by the plaintiffs, payment in respect thereof would be made within a period of 30 days or within reasonable time by the defendants to the plaintiffs. Kindly mark this part, my lord. In case of delay and on non-payment, the outstanding amount as on that day would carry an interest at the rate of 18% per annum payable from the aforesaid bank accounts to the plaintiff. I pause here. So there's a clause which they have admitted,
Yes.
that if there's a delay,
Yes.
there will be an accrued interest.
Yes.
So it can't be, my lord, that they are going to be out of pocket. For the delay, they'll have an accrued interest to which they are entitled to. That's their own pleading. This, my lord, takes it out of the ambit of that grave urgency, that if this money goes, if this money is not paid, I'm taking, my lord, the facts in the plaint to be true and correct while I'm arguing Order 7, Rule 11.
Correct.
So, my lord, they state there's an extreme urgency, but they also state that this amount which is not paid, if there's a delay, there's an interest component of 18% per annum payable. So, injunction and damages, that's what I'm trying to, my lord, indicate.
So as per your submission, once there is a provisions of interest in delay,
My
so
lord,
there
there
is no
can't
urgency.
be any urgency for an
That's-
injunction.
there is no
Yes,
urgency.
I'm very grateful.
So they will get.
If
If at all this court find that this case is find truth,
I am
so
grateful.
he will get the principal amount along with the interest.
Grateful.
That is your
That's my first point. Because thereafter, but kindly see the urgency that's at paragraph 29, page 15 of the plaint. One paragraph where they plead urgency. This is the paragraph which they seek to make out a case for 12A.
Yes.
But paragraph 29.
Yes.
Defendants have repeatedly
Yes.
tried to deny lawful claims of the plaintiffs. The defendants first manufactured a purported undated deed of settlement in order to assert that there has been a full settlement between the parties. I pause here for a moment, my lord. This is the fulcrum of their submission. They say there is a deed of settlement, and for this, my lord, I have to refer to their pleading with regard to this deed. So kindly take up page 11, paragraph 19 of the plaint. I'll come back to this, my lord. Kindly take up page 11, paragraph 19.
Yes.
However, on or about 11th of August 2024, when the representative of the defendants visited the office of the plaintiffs, a purported undated deed of settlement was shown. So according to them, my representatives went there,
Yes.
showed an undated deed of settlement,
Yes.
which inter alia contained
Yes.
an alleged representation that the plaintiffs have already received the entire outstanding amount, and that there remains no amount due and payable by the defendants to the plaintiff. A copy is annexure F. Kindly take up volume 3, page 393, minute of the plaint. Volume 3, page 393. This is the document which they are referring to, Millard. Page 393, volume 3, Millard. 4 lines titled as Deed of Settlement. Millard, kindly see who has signed this document. Pawan Khaitan, Director of Khaitan International PTE. That's the plaintiff in the proceeding, Millard. That's not us. And next, Millard, Manish Khaitan, Director of Caprico. That's plaintiff number 2. Not us.
Yes.
So, Millard, we are a listed company. Their contention is there's a deed of settlement which is 4 lines. What it states, Millard, kindly permit me to read this document, Millard. We, the undersigned, being the directors of Khaitan International PTE and Caprico International PTE, have already received rupees so-and-so from APL Metals. Millard, we are APL Metals. And have stated that they have no claim against APL Metals Limited and have no further claim from APL Metal signed by the directors of. This is in our cases. This is manufactured by you.
Yes.
It can't be manufactured by us. There's no signature. We have never content. There's no document to show this is our document.
Yes.
This they very conveniently manufacture with their signs because they know that otherwise they may land up in trouble. They very innovative, my lord. Their signs are there. Our signs are not there. No signature.
Okay.
This they rely on, and they content in page 11, paragraph 19, that our representative went and showed this document to them.
Yes.
And this is the document they refer to, my lord, in the urgency at paragraph 29. Lord, may I request your lordship to come back to page 15, paragraph 29, my lord.
Yes.
Where I stopped, my lord, the first 4 lines. The defendants thereafter tried to attack the officers of the plaintiff and or directors thereof through hooligans in order to threaten plaintiffs
Not
to claim any further amounts from the defendants. However, both such attempts, defendants had failed. Even thereafter, defendants acknowledged their dues even before the learned court trying the criminal complaint of the plaintiff. Since all attempts, there's a separate proceeding which is pending for quashing the criminal proceeding. That's a separate proceeding.
What is the proceeding? 420?
482 minutes.
No, what proceeding initiated criminal court?
Which provision was initiated? I'll have to cross-check that, because I'm not involved in that part.
482 initiated under which section?
Must be cheating, must be 420. Must be.
468. Against this document? Against this document?
Against this document. Against this document.
Yes.
Since all attempts, and my lord, I'm also instructed that they have got bail, and my lord, the challenge to the proceeding is pending adjudication. That's the, my lord, stage of the proceeding.
482 is stay granted.
482, my lord, that's 482 is still one. It's still pending. That's what I'm given to understand. Pending. It's pending, my lord.
Yes.
Lawful claim of the plaintiffs have failed, and defendants are now trying to dispose of and alienate and or siphon off and or misappropriate sums lying in their respective bank accounts situated at
Indian.
And these bank accounts are given, my lord, and both situated within the jurisdiction of the defendant. Number 1 also has immovable properties, and the list of immovable properties are given, my lord. And then, my lord, after 7-8 lines, defendant numbers 3 and 5 have an immovable. That's not, my lord, with us. Some other immovable property. My lord, kindly see thereafter being aware of their personal guarantees. That's, my lord, for the other defendants. Defendants are also taking steps to alienate and or create third-party rights in respect of such immovable properties in order to defeat the claims of the plaintiffs. Mere pleadings, my lord. Nothing to substantiate. In view of the precarious financial condition of the defendants and in view of repeated criminal offense, I pause here for a moment, my lord. For showing, my lord, precarious financial condition, there is no document. No accounts, annex, nothing. My lord, our case is that, my lord, for the period from November 19, 2018 to 9th of March 2024, there has been a transaction of more than, my lord, 1159.01 crores, which we have paid to them. And this payment is through bill of exchange. Because, my lord, we have to pay in Singapore. And I'll indicate that's what we have stated in the Order 7 Rule 11. That's why my second point comes in with regard to jurisdiction. In view of the precarious financial condition and the repeated criminal offences committed by the defendants, and furthermore, in view of the malafide conduct of the defendants, there exists immense and reasonable apprehension that taking illegal advantage, the defendants would try to frustrate the claims of the plaintiffs by creating third-party rights and siphon out funds lying in the aforesaid accounts, aforesaid banks. The plaintiffs have further come to learn that the defendants have various other bank accounts and the amounts lying thereat are also being siphoned off and or misappropriated, and such accounts are also being used to route and reroute the funds lying at the bank accounts maintained with Indian Bank and Axis Bank mentioned here and above, which are as follows. No documents to indicate what they have pleaded siphoning. How siphoning? They have come to learn. They say we have siphoned out funds. No documents to substantiate this at all. Bare pleadings. Unless the defendants are restrained from committing the aforesaid illegal acts, the legitimate claims of the plaintiff would be frustrated. In such circumstances, the plaintiffs contemplate urgent interim reliefs in the suit and hence are entitled to and accordingly pray for dispensation of 12 days. But after your lordship's decision, my lord, in good faith, that I'm carrying that judgment, you have the copy of the judgment ready? Good faith. You don't have it?
Okay.
But Hanbath fuels we are carrying. Good faith is, we'll get the, my lord, on the next day. Because Dhanbad Fuels was after your lordship's decision, but exactly what your lordship had held, my lord, in good faith. My lord, upon consideration of the previous decisions, my lord, your lordship had considered all the decisions, my lord, ASA International and the previous ones. And my lord, thereafter, your lordship had held that since there was no urgency, even if, my lord, it is taken into consideration and there is no urgency which is later on seen, my lord, then 12A, my lord, is supposed to be, it's to be declared that it has not been, the mandate has not been fulfilled. Hence, Order 7, Rule 11, my lord. Dhanbad Fuels, my lord, goes a step further. Now the law is clarified that anything beyond that date, 22nd August 2020, Dhanbad Fuels, my lord, has bifurcated it in two parts. Prior thereto, you can keep the suit pending and send them for mediation. Post this date, my lord, 2020, if there's a filing, my lord, then this has clarified, my lord, that no leave is required. Because there is no provision akin to Section 80 of the CPC, so there is no leave required. But if thereafter it is seen in two circumstances, my lord, if it is granted, the injunction, and if it is refused, both, my lord, will be again looked into. If a challenge is, my lord, raised to the 12A.
Correct.
And, my lord, there it states unequivocally, my lord, that this is a mandate which is to be followed. Let me hand over a copy of the decision in Dhanbad Fuels. Sir, 2025 SCC online, SC 1129. I'll hand over a copy, extra copy. Well, should have got it. Thank you for it. Supreme Court 1129. Well, I'll refer to the judgment a little later, my lord, because this is the proposition. When I'm not finished with these facts, I'll come to the judgments.
Yes.
I also want to show, my lord, good faith before I show this. Now, this is the angle for, my lord, 12A. And the substantiation of the urgency is not to be done by mere pleadings. I'm carrying a few judgments on that line, my lord. This is my first point, 12A. My second point, my lord, is with regard to the jurisdiction. My contention is, what is the modus operandi that has to be gone into? My lord, this is not merely my not paying them money. You know, the modus operandi is, you know, the period involved is from November 19, 2018 to 9th of March 2024 when this export happened. You know, this period, lead metals and scrap was, my lord, being exported by the plaintiff from Singapore to India. So it's an export case, my lord. You know, bills of exchange were issued for the imports. This was paid by the defendant number 1 to the tune of 1159.01 crore for this entire period. So what they're claiming is 60 odd crores. You know, they are not indicating, you know, this 1159 crores is the entire transaction which has happened. How? What is the modus operandi, my lord? The plaintiff first issues a sales contract. But this is for the forward sale of the quantity of goods. There's a commercial invoice which is generated, which, my lord, is all on record from pages 53 to 373 of the plaint. Very interesting, my lord. This commercial invoice indicates the quantity and the value of the goods.
Correct.
There's a packing list to this. There's a list of things, my lord, which is to be given with this. Packing list, beneficiary certificate of origin. There's a beneficiary certificate of war materials. You know, then there is a transboundary movement in Form 9. And there is a transboundary movement in Form 6 and the bill of lading. With these documents, my lord, which are to be given by the plaintiff, you know, the payment is made by bill of exchange by defendant number 1, payable at Singapore.
To whom is the document is to be given?
The document is to be given to the defendant. These documents, and then, my lord, we then make this payment. Now, what happens here is, my lord, with all these commercial invoices which are on record in the plaint, there's no provision for supply of goods on credit. It's a very important point, my lord. Because today, my lord, if this is not to be paid on credit, that means either I pay for it or, my lord, I don't get the goods. Yes. My lord, there's an agreement of 29th of June 2024. This is, my lord, with regard to the personal guarantees, which we are not considering. My lord, I am not arguing on behalf of defendant numbers 2 onwards.
You're not there.
No, my lord. Only for the company.
Correct.
Because we are not party to this agreement. My lord. 29 June, we are not a party. There are 2 letters which they have relied on heavily, saying there's an admission. These 2 letters, my lord, do not talk about the outstanding against commercial invoices. There is no whisper. But with regard to outstanding of commercial invoices, I'll rely on Negotiable Instrument Act section 135 onwards. What happens when it is a foreign seated, my lord, transaction? There, my lord, the jurisdiction is very clear. If it's a bill of exchange which is payable at Singapore, and if there is a dispute which arises therefrom, if they are aggrieved, they have to approach the courts in Singapore. You have got the Singapore law. Mandeep. The rains have troubled my lord. I understand a lot. So, my lord, I am helpless. But I have to show, my lord, provisions. These, what I'm arguing, my lord, is there in the Singapore law, my lord. That this part has to be done. Otherwise, and very important, a notice has to be issued of default. Without a notice of default, my lord, there's nothing on record to show that there's a notice of default which has been issued.
But there is no written contract.
There's no written
No
contract.
written
There
contract.
is. Because commercial invoices will be the contracts, my lord.
Correct.
Commercial invoices will have
Correct.
the
Contract.
conditions there,
In the that's why the
My lord.
commercial contain the conditions.
lordship.
Their conditions, whether it is provided in the forum selection clause.
But there's no forum selection clause. My lord. I'm going by, my lord, the angle that if it's a bill of exchange, which they cannot, my lord, deny, it's a bill of exchange.
Correct.
With a bill of exchange where, my lord, it is payable at Singapore,
Okay.
the jurisdiction will be in Singapore. That is my short point.
Payable at Singapore.
Payable at Singapore. So, my lord, it is
But
then
if
to be
it is
paid.
payable at Singapore, but the cause of action arose also in
The
India.
part cause of action is very important. My lord, kindly take up paragraph where, my lord, they deal with the cause of action is
So,
paragraph 27.
Because payment made,
My lord.
item delivered, part cause of action India.
If the payment is made, an item is delivered, my lord. Now, kindly see, my lord, if there's a bill of exchange angle where, my lord, there's a shipping, because these are
That
goods,
is-
my lord, which come by the water. Now, once they, my lord, are unloaded, until the payment is made, there is no provision for credit in the commercial invoice. So, my lord, if I have not paid, so that's, my lord, where the issue comes. If the payment is in question, it has to be through the bill of exchange. The bill of exchange is payable at Singapore. So, if the dispute arises that you have not made this payment, because they say you have never complained about the goods. That's their pleading. That you have never complained about the goods, you have utilized the goods. If you have utilized the goods,
Could I
then
have the
whether the
lordship's leave?
Yes.
My
payment,
learned friend is on blood. Deep waters.
International
Deep
law.
waters. Deep waters.
I was moving the anticipatory bail application in the wildlife. So the public prosecutor has raised, stated that the judges put the question, where is your evidence? The public prosecutor has evidence in the mid-sea.
Blood in this case, blood mid-sea and sunken.
I'll try to, my lord, keep it afloat. My lord, the paragraph 27 is, my lord, where they plead jurisdiction. Lordship will kindly take up page 14. This is the cause of action, my lord. Paragraph 27. In as much as the defendants made payment of various amounts to the plaintiff from their bank account, and the account details are given in Calcutta, my lord, both Axis Bank and Indian Bank, both within jurisdiction, and since the defendants agreed to make the entire payments together with interest on account of goods sold and delivered by the plaintiffs from the aforesaid bank accounts situated within the jurisdiction aforesaid, and in as much as the defendants have acted upon the agreement pleaded in paragraph 5 hereof, and in as much as the defendants are situated outside jurisdiction aforesaid, part cause of action. So, my lord, they go by 20 subsection C. This, my lord, I will indicate that from the law, 135 of the Negotiable Instruments Act and the relevant provisions of the Singapore law, this could not have been, my lord, even a part cause of action. They have stated this amount is paid through the banks in Calcutta.
Correct.
This is through a bill of exchange payable at Singapore. So, my lord, it is not relevant as to where it originates from, because today,
Together with interest on accounts of the goods sold and delivered by the plaintiff from the aforesaid bank accounts.
my lord, so it's not paid from these accounts, my lord. It's the bill of exchange, my lord, is a separate document. It's like a demand draft, which is, my lord, now that is payable at a certain point. Here, my lord, it is payable at Singapore. If they say that payable at Singapore has failed, so, my lord, the cause of action arises there, not here. That's my second argument, my lord.
Okay.
And these are the two arguments broadly, my lord, for my Order 7, Rule 11. First being 12A. The 12A I have shown, my lord, they have no case for urgency.
Yes.
And in a transaction where we've already paid 1159.01 crore, and when they're claiming 60 crore without any documentation, and the only document they refer to is, my lord, our contention has always been this is a fraudulent document.
Yes.
You have manufactured this document to make sure that we are in trouble.
Okay.
And unfortunately, we are in trouble because of this document. So, but I'll only indicate this part. I'll not take more than 15 minutes. I'll indicate those judgments, the relevant paragraphs, and I'll conclude my submissions.
Have you filed an application? No. So when the 120 days is going, when you receive the writ of summons? You file in the department. File in the department. Liberty department number. Liberty is given. Interlocutory application of 1, GA1. Correct. Liberty is given to submit the written statement in course of the day, subject to acceptance by and record an order. So and so appearing for the plaintiff, so and so appearing for the defendant. One, Mr. Bag, you are for what?
Defendant number 1.
So and so appearing for the defendant, and you are for the 2 and 3, madam. 2 and 3. Who is appearing for 4? 4 is there.
No.
2 and 3. What about the other defendants?
Lordship, we have received the written statement on behalf of defendant numbers 1, 2, and 3.
Writ of summons served upon other.
Served on all of them, Your Lordship.
None appears on behalf of the other defendants. Police counsel for the defendant number 1 has argued the matter in connection with GA4 of 2025. But due to paucity of time, argument could not be completed. Police counsel for the defendant number 1 and 2 and 3 press for time to file affidavit in opposition in connection with GA1 and GA3. You are GA1 and GA3. GA1 and GA3. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. This is the matter. When?
Any that suits you, Lordship.
This is the matter on 3rd of July 2025 for hearing of GA4 of 2025. 3rd
It
July.
may be any other day on the 3rd. I may not be.
7th July.
My lord. Very deeply obliged.
No, I'm for the defendant.
Yes. Rajgaria Timber. Which for the plaintiff?
I do not know it. Plaintiff is under resolution. Plaintiff is under resolution.
Resolution.
Yes.
So,
The order dated 16th December will reflect that, though I have not filed my written statement. But GA1 is pending, that is judgment upon admission.
nobody is there. So and so appearing for the defendant.
I've been told by Miss Shananda Ganguly's clerk that she is on her legs in
Who?
court number for the plaintiff.
Who?
Shananda Ganguly, Miss Shananda Ganguly. She's praying for a short Passover. She's on her legs in court number.
Passover.
My lord, I appear for the plaintiff.
Hmm.
My lord, we are out of time for filing the affidavit of evidence, my lord.
Hmm.
There are certain extremely extraneous circumstances due to which we could not file. It
Hmm.
is ready, but at the last moment, due to a fire in the Advocate and Records office, it could not be filed.
Hmm.
Lord, I am seeking one last opportunity. Within a week, within a fortnight, my lord, we will file.
What?
Lordship, I appear on the defendants, Your Lordship. My learned friends have been seeking for time since December 2024, Your Lordship.
No, the defendants have filed their admission denial only in December 2024, my lord. And we are out of time, my lord.
How it can be? 9 September 2024, the issues were framed.
No, my lord, will kindly see the order of 18th December 2024. My lord, I'm
Did
seeking
not
one
file
final chance, my lord.
Counsel for the defendant be kept with the record. Maybe.
My lord, we are out of time, my lord. My lord, we are seeking one final chance.
December, January, then February, then March, now June.
Yes, my lord, what has happened is the suit is of 2015. My client has taken some time to collate all the invoices that he's relying on. My lord, the
Inspection was done. Why the call? Inspection was done. You filed the judge. You have not filed the judge's brief document.
No, my lord, we have not been.
So how the suit will proceed? In the commercial suit.
My lord, we shall kindly grant us a fortnight's time. My lord, we will do all the necessary compliances.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff prays for extension of time to file judge's brief of document and examination in chief affidavit of evidence of the plaintiff witness number 1. Counsel for the defendant raise objection and submits that since the month of December 2024, the plaintiff is taking time and not filing the affidavit of evidence. Heard the learned counsel for the respective parties, this court finds that issue have been framed in the month of September 2024. Since then, the plaintiff failed to adduce the evidence. For the interest of justice, the case is adjourned. The plaintiff is directed to file the judge's brief of document within 2 weeks from date. List of affidavit of evidence be filed within a week thereafter, after serving the copy to the learned counsel for the defendant. Let the matter appear on 10th of July 2025 for witness action. It is made clear that एक काम करो डेट दे दो 19th of August 2025 at 2 p.m. for witness action. It is made clear that on the date fixed, if the plaintiff failed to file the bring the witness and file affidavit of evidence and judge's video document, the suit will be dismissed.
I'm grateful.
Oblige, Your Lordship.
My junior.
Yes.
My lord, I am appearing on behalf of the plaintiff, my lord, in a suit for recovery of money with respect to sale of certain goods. My lord, a CIRP was appointed in this matter, who has subsequently empowered my learned advocate on record to represent the plaintiff company. In the meantime, my lord, the defendant could not file their written statement, for which, my lord, your lordship's last direction was to list the matter as an undefended suit, giving liberty to the defendant to only cross-examine my plaintiff witness. This is the last direction. No, my lord, that direction was not there in your lordship's last order. But my lord, today I would be asking for your lordship for direction upon me to file the judge's brief of documents and my lord, some time so that I can, my lord, adduce my witness.
So appearing for the plaintiff. So appearing for the defendant. The plaintiff prays for time and prays for direction for filing judge's brief of document and affidavit of evidence of the plaintiff witness. Let judge's brief of document be filed within 2 weeks.
My lord, a month. My lord, I will be requiring a month.
Why?
Yes, because in the meantime, the official of the
in 4 weeks, full stop.
I need
affidavit of evidence be filed within a week thereafter, after serving the copy to the learned counsel for the defendant.
Yes.
Let the matter appear. Give the date.
Let
the matter appear. 19th August at 3 p.m. for witness action.
I need a liberty from your lordship, my lord, to incorporate one document in our judge's brief, which is not with the plaint. This is, my lord.
Commercial suit, how?
No, this is, my lord, this is subsequent document.
Come with an application. No, come on.
No, my lord, this is a general diary where the official of the CIRP has lost certain documents.
No.
Very well, my lord, I'll take appropriate
GA1 may be decided along with the suit.
What is the GA1?
Judgment upon admission.
No. It doesn't have a prayer for judgment upon admission. It is for attachment before judgment and security.
Okay.
It's already in the undefended list, my lord.
It is undefended. He is not pressing for the GA1.
At this stage.
When he prays, then we'll see to that. Yes, next.
Okay.
Lordship, item number 16.
Yeah.
So I was appearing for the plaintiff. So
Yes.
this matter was appearing for the witness action, but the difficulty is now the witness is not keeping well for some time. So I was only praying that this precious time of the court can also be saved if my learned friend do not object to an appointment of a commissioner. This can be done through commission.
Court is having objection for appointment of commissioner because of the impression of the commissioners.
Oh, that I don't know.
The last four years, only 2 cases the commissioner has filed the report out of the 20 cases.
Then I will not pray for this order. Then I will not pray for this order.
Bad experience of the appointment of commissioner. Initial days, I was thinking that the advocates will find something from this court, but after the appointment of commissioner, none of the commissioner is proceeding with the matters. Every time when the date is fixed, extension of time.
But in one of my matter, your lordship has appointed a commissioner that is going very well and
That's
on
why
a very expeditious basis.
So and so for the plaintiff, so and so suffering for the defendant, counsel for the plaintiff, press for fixing a specific date and time for further examination of the plaintiff witness and cross-examination. In view of the submission, let the matter appear on, give the date, 21st of August at 2 p.m. for witness action.
21st August.
Yes.
Grateful. Grateful.
Your Lordship, I'm appearing for the plaintiff. This is an undefended suit. It is kept for witness action. Your Lordship, I kindly pray for your Lordship to fix a date.
Why not today? Today there is time.
Your Lordship, my witness is traveling for work this month.
From?
He's traveling from Kolkata to Chennai this month. So
today, where is your witness?
Your Lordship, the witness is not here today.
As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 10th July. For witness action. Next.
I know in this matter,
for the defendant.
I had to file the judge's brief, but due to knee replacement of the advocate and the court, my lord, they can't be prepared.
Huh?
They could not be prepared. I seek
what could not be prepared?
The brief, my lord.
Judge's brief?
Yes, my lord. Because the replacement was made of the knee replacement of the advocate and the court. I seek 1 month time.
So suffering for the plaintiff, so suffering for the defendant. Counsel for the plaintiff prays for extension of time to file judge's brief of document. Let judge's brief of document be filed within 3 weeks. Affidavit of evidence be filed within 2 weeks thereafter. Give the date.
My lord, within 1 week not possible because the replacement is made.
Judge's brief of document be filed within 3 weeks.
Yes,
Affidavit of evidence within week thereafter.
Yeah, I say.
21st of August, 3 p.m. for witness action. Next.
I appear for the plaintiff, Lordship. This is undefended suit, Lordship. The plaintiff is situated in Mumbai, the plaintiff company. I was humbly praying if your Lordship would kindly fix a date, the witness would come from Mumbai and witness would be recorded.
As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear on, give the date. Have you filed the judge's brief?
Lordship, may I file my examination in chief?
Judge's brief you have filed?
There was a direction to file statement of truth, list of documents, affidavit of documents that has been filed. Judge's brief of document, there was no direction, Lordship. Since I've already filed documents, Lordship, in my most respectful humble submission.
The plaintiff, so suffering for the plaintiff has filed the affidavit of evidence.
Chief, yeah, Lordship, I have.
The same be kept with the record. Counsel for the plaintiff prays for fixing a specific date and time for examination of the witness. In view of the submission made by the counsel for the plaintiff, let the matter appear on 25th of August at 2 p.m.
Lordship, it's an undefended suit. Let it appear.
25th of August at 2 p.m.
Time बोल लें? Grateful, Lordship.
Your Lordship, let me take up item number 20 because that also date needs to be fixed. The plaintiff's witness action is over. The affidavit in chief for the defendant's witness has
Which for the defendant? Okay, we'll call after. Yes, next.
11:30. My section 34 application, we have concluded our hearing.
Yes.
And I'm to begin. My learned friends have argued. Your Lordship may remember, but I don't in July last year. The main argument was there. Then after that, there was several other sittings. But I'll just quickly tell my lord what the matter is about. Of course, my contentions are that no grounds, that's my first, no grounds have been made out under section 34. Because there are four main objections taken by my learned friends. One is that this agreement is not registered. This is the first. And our contention is this is an investment agreement. This is not an agreement for transfer of right in immovable property. So that was their first point, which has been considered, which is within the domain of the arbitrator, has considered, and it has been held. Second point is that the agreement was modified by an oral agreement. So if they are contending it should have been registered, then that amendment also should have been registered. But in fact, that second supplementary agreement which they are referring to was never signed by our client. So there is no modification. And the arbitrators again have decided, this is a point of law, evidence was placed, and they have decided. The only point, main point that my learned friends argued was that under the modified agreement, the price, the original price of the flat had reduced, and we have paid only the reduced price. But our case is that we were to pay as and when they demanded invoices, and whatever they've asked, they've given, and we are always willing to pay the original price. It's about 5 or 6 or maybe about 9 lakhs more than what we have to do. So that was the second point. First was registration, second was modification. Third, they said that this claim for interest is barred by limitation. The fallacy in their argument is that it was a claim for compound interest. So every year I get a fresh cause of action. And that again the arbitrators have dealt completely. And the last point, the fourth point they've made is that they were entitled to certain what's C for? C for what? For maintenance, CAM charges, Malad, for common area and maintenance charges. They are entitled to a certain sum, which was rejected because there is nothing about that in this agreement between the parties. That is that was in the alleged supplementary agreement. So these are the 4 points, and all 4 are wholly within the domain of the arbitrator. So this morning I was thinking, I don't think there is actually much more for me to say, but, and I'll elaborate on this. They have cited about 8 or 9 cases on each point, and they have taken my law through the entire evidence, and they've gone into it in detail. And so the only other point they seem to have taken is that they had proved certain letters which the arbitrators have not considered, and therefore it is perverse. But the arbitrator doesn't have to look at each and every letter. But we have made a chart. All the letters they have referred to, fortunately, are at least referred in the award itself. Award is given, my lord, by 3 learned senior advocates of this court, and they have considered more or less the every point that was taken. So today, my lord, your lordship has given me today and tomorrow at 11:30. Yes. So today I intend to take my lord once quickly through the agreement, because we really stand, and all these arguments stand and fall on the agreement itself. Yes. Though, of course, with the rider that this is completely in the domain of the arbitrators, and they have considered it. And I want to show the award, because my learned friend has placed the award in bits and pieces, but not in a consolidated way. So these 2 things will more or less take care of what I believe my learned friend's arguments. Then I'll deal with the cases. So if my lord comes to volume 1, page 19 first, they have given some. And the claimant's name is now NR Oil Offshore Drilling. At that time, it was Steel Fabs. So page 19, there's no dispute on that. So the agreement is dated 31st December 2006. Yes. Now I'll just make one before I begin, Malad. This is the agreement which was which contains the arbitration clause, and we invoked. Malad, before that, we had invoked. They had taken out. They had given us a notice for winding up of our company for claiming those scam charges. There also, they have only referred to this and not the 2012 agreement. So there was, because there was no agreement, so according to us, anyway. So those, when they made their claims, which is now culminated in a counterclaim, they had only relied on this, and nowhere has it pleaded that this was modified. So this is the agreement of 31st December. Now the preamble at page 20 is important only for the sense to what is the nature of this agreement. Now A to C is how they got the plot from the West Bengal Housing Infrastructure Development, and they were to promote them. Now D is important. Contemplating good investment prospects in the synthesis building, that's the building they were going to make, the first party, that's my client, has offered to invest in it, which the second party has accepted on the terms and conditions herein contained. So this is ours is a company based in Bombay. Only for the sake of investment, we did this. Then, what is the agreement? Then, one, the first party is hereby booking 11,407 square feet in synthesis building at such rate. So it's a booking agreement. It's for investment and I'm booking it. That doesn't give me any right in the immovable property so as to, or it doesn't involve a transfer of right of immovable property so as to require registration. And the stamp point was also taken, but that after NN Global, my learned friends gave that up, that the arbitration is not maintainable because there's no stamp. So, my lord, this is booking, and then, my lord, if it comes to the last line of that paragraph 1, the second party has accepted such booking on the terms and conditions herein. Now, what were the terms and conditions? Present payment, I was to make them about 1.5 crores payment, 149 crores. Yeah. I made that payment, down payment. Then the balance booked amount, we were to pay 3,20,000 odd at within 12 months, which we paid, and after that, the interest rate would change. Yes. So that is also not important. We have paid that. Now, this principal sum that we have paid for our flat, about 2.5 crores, I have not claimed in this petition, in this arbitration. Only the interest.
2 crore 65, that is the total amount.
Total amount. But we have paid, according to them, the invoices they've raised, 2 crores 53 lakhs.
Okay.
So, but that entire amount is paid and not claimed in this arbitration. Then other payments, not so important. These are the extra payments that they required. As and when they asked us, we have paid. Then the car park is there. Now, if my lord comes, the important part, because mine is only a money claim. 6, 7, 8 and 9 are important. 6, interest. From the date hereof, that's 31st December 2006, till possession date, present payment shall carry interest at the following rate. So, A, for the first year, January 2007 to January 2008, it will carry interest at 9.5 per annum, compounded yearly. So, this is only for 1 year. Now, this amount, my first point that my learned friends took was, this is barred by limitation. But this amount, when it comes to 18th January 2008, it becomes a part of my second claim. I have not claimed this separately, this 9.5, because it merges, it becomes the principal sum, and then my compound interest starts. Then my lord will see 6B. From 19th January, after payment of this 3,20,000, the total amount paid, along with the car booking amount, shall carry interest of 11.2% per annum, compounded yearly till date of possession. So that whatever accrued on my first 1.5, the 9.5%, that becomes the principal amount. Then I add 3,20,000. And from that date, that is 2018, 18th January 2008, I get 11.2% interest till date of possession.
The first part is 9.5%.
9.5, that becomes a part of my principal.
And second year started from the 19th January.
Yes. So I have claimed 6B.
Yes.
6A is already merged into 6B. I'm not claiming double. That's all I'm saying. Then that goes on. Then the last sentence of 6B, this interest amount will accrue towards the account of the first party and will be adjusted towards the final balance payment made by the first party to the second party. Well, if I had paid less for the principal amount, they are always free to adjust this interest against that.
Yes.
I have paid whatever they have told me to pay. I have reserved my right to claim my flat, to claim specific performance. All that is not the subject matter at all of this proceeding. Then 7.
No,
Return.
First to clarify, A is this July 2007 to 18 January 2018.
On 1.49.
Correct. 1.49.
Yes.
Correct. Of 9.5%.
Yes.
9.5%. Whether you are telling that you are not claiming because this amount they have not paid. This amount has been merged with B.
Yes, this merges because it becomes say 150 plus 10%, say about 1 crore 60 becomes the principal sum on to which I add 320 in B.
320.
Then I pay further 320 and these other charges.
19 June 2008 after payment, the 320 is the interest part of 9.5.
No. The interest, this is the separate payment.
That's why
After that, if I make the second tranche was 3 lakhs 20,000 only. After that, my interest becomes 11%.
Okay.
That's the agreement.
Okay.
So first year it was about 10%, 9.5. Then it becomes 11.2%.
Correct.
And none of these figures are disputed. The calculation, my learned friends have taken a broad point that we haven't proved the calculation. The calculation is just math. And we have given 2-3 times, both parties had to give the arbitrators, and arbitrators have referred to those charts. That is for the final calculation. But as far as the finding was that, yes, first 9.5, that merges, then 11% for some period, till the date of possession. Now, date of possession is a technical part of the thing. I'm coming to that. That's at 8. Then 7. This is the object of the agreement, is to get a return on my investment. As far as this agreement is concerned, I'll get the flat, that is a separate matter. Return. The second party shall procure tenants and or lessees for the entire booked area by the possession date at the best available rentals, provided the first party receives by way of rental for the entire booked area a minimum return of 13.42043% on the aggregate of the following. So it says that they will procure the tenant because property hasn't transferred. I have not become a landlord. The day they procure a tenant, they are saying your return on investment will be a minimum of 13%.
Yes.
So they will get that and I will receive that rent. And if I don't get that rent, they will, that's the paragraph 9, they assure us as a minimum guarantee sort of thing. I'll come to 9 just now. They will assure us that they'll make up this amount. I'm just reading then, so on what will I get 13.42%? The booked amount, car parking booking amount, the extras that I've paid, and 7.4, this was pointed out by my learned friends, the expenses towards stamp duty, registration fee, and any other extra expenses, such as deposits for transfer by second party of the booked area in favor of the first party. So if they pay any of this, then I should, if I pay any of this, then I will get interest on this. The claim I've made in this arbitration does not include 7.4 because that time has not even come. This agreement contemplates another agreement to be entered into, which is in clause 11. I'll come to that. So this 7.4, my learned friends have placed it. Your Lordship will note that this portion we have not made a claim on this. Our 13.4% is based on the up to 7.3.
Yes.
Because if I had to incur these costs, then I would have also got interest on that. But I didn't incur the costs, I haven't given. Now, this is very important. Possession date, because it's a technical term. The date on which the first party will start to receive the rentals for the entire booked area to be given under tenancy or lease by the second party will be deemed to be the possession date. The tentative date of possession will be December 08. Now, they did not procure, admittedly, in the evidence also they've admitted, they did not get a tenant for this area. So, this date didn't start, the possession date. But tentatively, they had said it will be December 8. So, we have taken as a reasonable time for 4 years, after 4 years of this date, to 2012, 13. So from 2012, we have pleaded that also, that since they didn't give us, we have started 13% from 2012, which was accepted by the arbitrators.
Reasonable expectation.
Saying that that is a reasonable time to be given. Because otherwise they take advantage of their own wrong. They don't get me a tenant and then they keep on paying me 11% instead of 13.4%. So this is the thing. Now this 9 is, what if they don't get a tenant? What is their obligation? Assurance of the second party. The second party is hereby assuring the assured amount mentioned in clause 7, which is 13.4% of the amount I have invested. And for the period mentioned in that clause, and in the event the rental receipts of the first party is less than the assured amount, the second party hereby covenants to pay the first party the assured amount and keep the first party saved, harmless and indemnified for all losses and or damages that the first party may suffer for non-receipt of the assured amount. Such indemnification may suffer
in the form of capital.
May be in the form of capital reduction commensurate to the first party achieving a return of 13.42 etc. % on their total investment as envisaged. Now, after reading this, the arbitrator's reaction was, who has written this agreement? They have written this. It's a standard format agreement to tempt investors. They're giving us really good terms. At 13% interest you're going to get on your money. So this was the intention. So if it has to be, if it was otherwise, they would have certainly taken the point, this is by undue influence, coercion, because it is totally on them. All the obligations are on them. My obligation is only to pay the amounts when they ask for it. That's paragraphs, clauses 1 to 4, 1 to 5, sorry, 1 to 5 and 10. These are my only obligations. Now, 10 is important only for one reason, though it never came up. Well, if we fail to do the essence, timely and due payment of the first party to the second party of the balance car parking amount, etc., etc., as and when called to do so by the notice period is essence of this agreement. In the event first party fails to pay any part or portion of the balanced booked amount, as mentioned in clause 3, the second party will be entitled to interest at the rate of 12% per annum, compound quarterly from the notice date till such payment is made. And in the event any 3 payments falling due, the second party will no longer be liable for the assured amount. Now, nothing was ever fell due, but this clause is important because the arbitrators have relied on it to say that you have asked for 12%. So ultimately, the interest they have given us is 12% per annum. Now, this 11, this is very significant. But what is the nature of this agreement? It's only investment. It is agreed by and between the parties that a formal agreement for sale will be given by the second party to the first party within 15 days for approval and due execution. On the approval of the same, the said agreement shall be executed forthwith, failing which the first party reserves the right to terminate this agreement and will be entitled to refund of the amounts paid till date along with compound interest. Manoj, admittedly, no agreement for sale was.
So this is your claim.
No, I'm not claiming this. I'm claiming my money.
Correct.
So this agreement for sale, because my learned friends, in their clients rather, in some correspondence, they refer to 31st December as an agreement for sale,
Correct.
which it is not. Then the nature, that's what the arbitrators went in, and that's why I'm taking this effort to place this agreement. It's a short agreement. The nature of this agreement is not the agreement for sale. It is a booking fee. I invest money in his building.
Yes.
And he builds and he assures me this return and says that subsequently I shall execute a formal agreement for sale. And after that, we will execute a conveyance.
Yes.
Now that stage has not come. I had a right, if he hasn't given it to me, I had a right to refund it.
Correct.
But I have not refunded it because I am getting better interest than the market at this rate. So I have no interest to, this agreement can continue. In fact, after this award, the client can even file another proceeding because another 2-3 years have passed and I will still be entitled. It's accruing because my principal sum of 2.5 crores is still with them. And till I get that flat in my name, it will continue to do so, or till they get a tenant and that possession date comes to fruition. Now, this next clause, my learned
What
friends,
has happened to the building?
it's lying there, it's constructed. It's, I think it's the NGT building.
Commercial court is there.
Commercial court is there, National Real Tribunal. That's it's a. I haven't been to that. I haven't been to the. And it's got a nice cafe on the top which overlooks that eco park. So it's a very good building in that sense. But mine is a offshore drilling company. We are not interested at all in coming and staying there or doing business. We did it for the investment. When we get the flat, we will sell it or whatever we will do with it. That's now this 12, my learned friends relied on clause 12 during the course of their argument to say that some right must have been transferred, because otherwise what is this right of first purchase? It says, in the event the first party intends to dispose of any part or portion of the booked area or the booked car parks, if any, the first party shall have to first offer the second party to purchase the same, then at the prevailing market price. So if the property, the title has not come to me, the question of me selling it doesn't arise. This is to sell my booking right. It's the booked area. So what they tried to argue is, see, that therefore this agreement, they showed our client, in fact, this agreement and said, do you have any right in this agreement? He said, yes, I objected to it, knowing that this is going to be the argument later. It's subject to objection. He says, of course, I have rights under this agreement. And then they said, see, the client has admitted he has rights under this agreement. Therefore, it should have been registered and stamped. But the agreement has to be read as a whole. And then duties and penalties, all stamp duties, etc., will be borne by me. And then the arbitration clause. Which? Yes. Well, as and when we were called upon 1 to 4 were my obligations, I have paid all the sums. Now, that is their only hook that they've argued now. In fact, they argued that before the arbitrator also, that no, look here, if the price was 265, I have asked them for 253. If there was no modification, why would the price be less? But till now, the question of the price of the flat doesn't even arise. It's what is the aggregate amount I have invested, and I am to get interest on that. So it's straightforward. So that is my money claim. We filed the arbitration. Then, my lord, we filed our letter invoking the arbitration was of 6th June 2018. My lord will see page 40 of the volume 1. I'm not placing the whole thing. It's just what I read out. But this was my claim through my constituted attorney. I made this claim at page 40. It's a detailed letter going through the entire agreement. And after this, they gave a reply to this. They denied. This is at page 45. Just for the record, I'm just telling my lord what happened. In fact, if I place this, it would cover all the facts, but I want to quickly place the award. So I don't want to repeat it.
Yes.
And their answer was 45. Then we went to arbitration.
Yes.
The statement of claim, if my lord wants to know, then it's at page 3 of volume 1, and the counter statement is also here at page 55. These are the relevant records. Now, my lord will take volume 4. Volume 4. The award. Page 659.
Yes.
659, the tribunal is there. Unfortunately, Mr. Sharkar has passed during COVID. Mr. I don't know if my lord saw him. He used to be a Shama Prasad Sarkar. Anyway, page 60, my lord. It begins. The paragraph 1 is how they were appointed. It's not relevant.
Yes.
Now, if my lord comes to paragraph 2, the background. It's a 30 paragraph award, not too long, terse, but I'll run through it very fast. My lord. Paragraph 2, background. The claim and controversy arises from a most abysmally drafted document. It begins page 661. Because the arbitrators couldn't believe that everything, all the liability was on the claim, on the petitioner rather.
Yes.
Being the agreement dated 31st December 2006, made between the claimant and respondent. The claimant contends that the agreement is an investment agreement, which provides that in consideration of the investment of a substantial sum towards eventual purchase of a designated area, along with car parking in Synthesis building, to be constructed by the respondent pursuant to a collaboration agreement dated 24th July with HITCO, the respondent would be obliged to pay interest on the sum invested by the claimant in the circumstances and manner set out. So it's investment. It is of utmost importance to examine the true nature of the agreement. First, to appreciate the real controversy and its resolution. Despite the claimant's assertion that it is an out-and-out investment agreement, it is clear that not only no such nomenclature has been used in any part of the agreement, the nature and tenure, the terms and tenure of the agreement, and to some extent, the shadow of a collaboration agreement dated 24th July 2006, that is with HITCO and them, noticeable therein, make it abundantly clear that the complex and elaborate arrangement of investment was steps towards final transaction of sale and purchase. Absolutely correct, Mala. No, I'm not denying that ultimately we were to buy the premises, but for them to build, I put in the money first and invested the money, and this agreement is only for my return on my investment. However, there is no denying the fact that the prime motive of the claimant in entering into the agreement was investment prospect, and on that understanding, the respondent had accepted the offer of the claimant. This is clearly recorded in recital D of the agreement dated such and such. I have shown that. And this is their interpretation, that this is clear, that there can be no doubt. Now, interpretation of the contract is within the domain of the arbitration. This is not contrary to law, contrary to the contract, etc. It was completely within their scope. Then, the scope of the disputes. The project under collaboration was apparently a long-drawn, time-consuming affair, and on that understanding, the parties clearly felt that a formal agreement for sale would be entered into in good time at a future date, to be followed by the conveyance. My lord will just note clause 11. This is exactly clause 11 of the agreement, that it will follow. The claimant apparently was not interested to enjoy the building for its beneficial or individual use or requirement, but as investment by way of return of money paid, and to this end, it was provided in the agreement that the purchase price would be advanced in separate tranches from time to time, carrying a varying but specified rate of interest. Again, with the same intention, it was provided that at the appropriate stage, the respondent would procure tenants, because it's going to be a long affair and title hasn't come to the claimant yet, would procure tenants for claimants to ensure a return on its advance calculated on the basis of clause 7 of the agreement at a minimum rate of 13.42 etc. % towards the purchase price at a specified rate, and any shortfall will be compensated. Shortfall is clause 9.
Yes.
Clause 7 and clause read with clause 9. 5. The claim raised by the claimant was categorically stated in paragraph 32 of the SOC is restricted to a sum of 18 crores 94 lakhs odd by way of interest and damages payable by the respondent by way of return on investment under the agreement. It is not a claim for specific performance of a transfer of the conveyance. The issue which thus falls for determination on this score is confined to the validity or correctness of the money claim. The claim of specific performance, termination of the agreement, or even return of the principal sum, that is 253, paid so far, are thus beyond the purview of the reference. So this is beyond the scope. I'm not asking back my principal. I'm only asking the interest that has accrued, because the principal will go towards the purchase price of my flat. The respondent, on the other hand, has claimed a sum of 60 lakhs odd on account of common area maintenance charges in the circumstances set out in the counterclaim, and a further sum of 17 lakhs by way of interest on such amount. The counterclaim is founded on the basis of a purported modification of the agreement dated 31st December 2006 at a meeting between the parties and incorporated in the minutes of 27 September 2012, raising further issue as to the fact and validity of such modified terms. Manoj, if I may stop for a moment, man. This their cases on 27 September 2012, there was a meeting of all the unit purchasers, and they alleged that my company was represented by my broker, not by the director, not by an employee. They were all there. They said, very well, I'll give you a supplementary agreement, and we will reduce the cost by so much. And what do you have to do? You have to delete clauses 6, 7, and 8, 9. So the entire basis of my agreement, this investment I make, I'm giving all that up. My claim is in 18 crores for a discount of 9 lakhs. I'm giving up my entire claim. So be that as it may, that minute itself again envisages that the supplementary agreement will be sent to you and you have to sign it. It was not signed. Our client, it was probably sent by email. We never signed it because we were not there. And that is, and none of our employees or directors were at the meeting. So it couldn't have been an oral agreement between two companies.
What has happened to this 27th resolution?
No, it's there. According to them, other flat owners have agreed to it, etc. But that is, each flat owner had to enter into an agreement. Admittedly, there is no agreement. There is no written agreement signed by two parties. So they are relying on an oral agreement which is allegedly recorded in this minutes. This minutes is not signed by me also. So ultimately, the arbitrators have found that this is not binding on us, this agreement. And the scam charges was based as a part of this agreement. I'll read out the entire agreement. Manoj, there was nothing to do with common area maintenance charge, because till I get possession, I don't pay any of these charges. So this is their main point, and this has been considered by the arbitrator, that they say by implication and by conduct of the parties, the agreement had been novated, and we were not to get any interest or any return on our investment, which is, the arbitrators have held that is unbelievable, because they are hard-nosed businessmen who have done it only for investment. Why should they give up their investment right all of a sudden?
Yes.
And in any event, there's no document. Then, matter of merit. Since the money claim raised by the claimant is solely based on the express terms of the agreement dated December 31, the relevant provisions are set out. I'm not repeating much. There's clause 6, 7, 8, 9, 10. I placed all those. Now 6, 6, 6 if my lord comes.
Yes.
Now in paragraph 7, the arbitrators just say they just sum up. It's not really relevant for the facts. What are the principles of construction of a contract?
Yes.
So if my lord comes about 5, 6 lines, that's 5th line below. First, the abiding concern of the claimant in entering into the agreement is that until final conveyance is executed, the claimant would be compensated for denial of its use of the money in the manner provided in the agreement. So they, according to them, what is the real nature of this agreement?
Yes.
I am to get an investment return. Second, any ambiguity in any clause of the contract should be interpreted against the party who drafted or created the document on the principle of contra profferentum rule, in case of any difficulty faced out in working the amount due to ambiguity in the terms. Admittedly, this contract is the standard contract document on the basis of which all unit holders and intended purchasers of synthesis buildings were entered into. Further, the court is not powerless to overcome difficulties by implying terms in the agreement to give business efficacy to the agreement or supplying a term so that the common intention is not defeated or frustrated, resulting in the unjust enrichment. It can provide a machinery that is workable. If I may stop here, Manoj, as a matter of principle, of course, this is sound, but he has not even alleged that any of these in the arbitration, no prayer is that clause 7 or clause 9 is not feasible, not tenable in law, and it should be set aside as void, etc. So this doesn't come in because in my respectful submission, there is no ambiguity. There's no need for implying terms also, which the arbitrators have. The principle is there, but they didn't do it ultimately. Thirdly, it is to be borne in mind that the nature of payment made by the claimant is payment on advance towards purchase price, and its character or nature does not change in the process of working out the contract or conduct of the parties. So basically, money has been paid, interest is to be paid. The conduct will not change this. This is my understanding of this. Then fourthly, it is clear for the provisions of 6B that interest accrued on the money advanced would be adjusted towards the final payment to be made by the claimant to the respondent, signifying the interest earned or payable pertains to the character of principal sum. So that is there. In case they say that I have paid less, they were free to adjust it, but that issue is not a subject matter of this arbitration. Then paragraph 8, this is my claims are summarized. So on account of principal amount, this is on 11%. I have claimed about 4.92. Your Lordship has seen 8. That's on 11.2%.
Yes.
And assured amount is 13. At the rate of 13%, it comes to about 6 crores. And the interest on the assured amount comes to about another 7 crores. So 18 crores. Then paragraph 9. We must note the claimant has not explained how the total aggregate pleaded in 32 is computed. In fact, the figure differs from that given in two other important documents, such as the notice of 6 June, that is the section 21 notice, and the purported computation given in the documents at page 29 and 30 of Shonjib Dalmia's affidavit. Now, my one thing, Your Lordship will just remember, one is Sanjeev Dalmia is the director and Sandeep Bansal is the broker. They keep in the argument, not intentionally because the initials are same, sometimes this was used interchangeably. The broker has no authority from our company.
Sanjeev Dalmia
is the director of the claimant, and that other, the witness, the respondent number, the witness number 2, no, he didn't give it. He didn't. The other broker. Who is this person? And the minutes were signed by Sanjeev Agarwal, who is their person. So names are a bit important in that sense. That was the confusion that was happening during submission. Then, so the arbitrator said that there is a little difference in the computation. Not unnaturally, the respondent's counsel was critical of such approach. At any rate, the fact remains, if the liability of the respondent is established, the relief can be molded in the appropriate manner. It's only a matter of calculation. Accordingly, in the course of hearing, we requested counsel of both parties to submit their respective calculations, subject, of course, to our decision on liability of the respondent. So we had given our calculation, and on that basis, they have given this. Then Manoj, the four claims, that one is on interest on the principal amount. This is where that argument of compound interest will come in and say that it is not. So interest and limitation is 1 point, I would say. Out of my 4 points that I've made, this is 1 point. As to the first head of claim, the computation errors apart, the counsel for respondent kept the point of limitation at the forefront of his argument. First, counsel contended that the payment due under 6A on 1.49 at the rate of 9.5%, the period of limitation commenced in January 2008 and became barred in 2011. The agreement appears to be rather contrived, having regard to the clear terms of 6A, which provided that the interest would be compounded yearly. Hence, the interest accrued in 2007-8 would become a part of the principal along with the second tranche of 3.20, attaching interest at 11.25%. So it becomes a part of 6B. The said contention of the claimant's counsel is further validated. This was my argument, it is accepted, by the fact that the claimant has not made a separate claim for 6A. So that first part goes. Then 6B now. Counsel for respondent urged in the same vein that since the interest for 6B was to be compounded each year's interest comprises of an independent and self-contained claim. And as such, the interest accruing in the years 2008 to 14 are all barred. So he's saying that each year is one claim. But I'm saying, no, it's a continuing claim. It becomes a part of the principal. The fallacy of this contention lies in the obvious fact that the interest for each year in terms merges with the principal for the next year. This is further corroborated by the express provisions of 6B, as noted earlier, to the effect, and it's quoted, the interest amount will accrue towards the account of the first party, and meaning the claimant, and will be adjusted towards the final balance payment made by the first party, meaning the respondent, to the second party. Consequently, the interest accrued for each year formed a part of principal until claimed separately at any time. So this is the arbitrator's conclusion that since the interest is accruing, if they wanted, they could have adjusted it against the principal price at any time. And this bigger arrangement, which the learned arbitrators have envisaged, that ultimately I'm going to buy the flat, well, that agreement is subsisting. So there's the jural relationship continues in that sense. That is also, I think, there in the it's the reasoning. 12. From a reading of 6A and B, it is clear that the amount payable on account of interest, either account is not payable on any definite date. In other words, there is no starting point to be found for calculating limitation and what article of limitation would be attracted. The nature of payment made or to be made by the claimant or interest accrued on such payment towards the purchase price pertain to the character of principal, subject to the right of the claimant to claim such accrued interest as and when. But these are the reasoning, but all I need to show in a 34 is they have considered it threadbare, the point of interest. So it was something within their domain and they have decided it. Even if they were wrong, they would have, which I'm saying they are not, but even if they were wrong, sometimes your lordships would not interfere with it because it's within their domain. Now this, I want to say that commercial sense, 670, about 4 lines from the top, such right should exist is a pure commercial sense, given that the sale transaction might take indefinitely long. Even in the event the contemplated sale and transfer does not materialize or the agreement is determined earlier, the claimant's right to recover the total amount paid and or the accrued interest would not be extinguished, but the respondent would continue to hold the amount as trustees for the claimant and would remain liable to return the same to the claimant. Here, the demand has been made by the claimant for a part of the total represented accrued interests from 7th June when the notice of 6th June 18 was issued for arbitration was received by the claimant. So from 7th June, we have asked. It is from such date only the period of limitation may be reckoned. So this is the first time, all this time, the money that was accruing as interest, this is the arbitrator's view, is that was really towards, it could have been towards the principal. Then unless I make a specific claim for return of my interest, and that I made in 2018, and so from 7th June, the period of limitation starts. And within this is a period of limitation to initiate this arbitration. But I start in the SOC was filed in 19 itself. Then 7th June. It is only from such date. It is from such date only the period of limitation may be reckoned. It is also significant to bear in mind that the claim has been made on the basis of damages by way of interest on account of denial of the use of money, adding a new dimension to the nature of the claim in the context of limitation. In passing, we might say that the council's argument as to lack of jural relationship, that is their argument, is equally misconceived because firstly, the contract for sale and purchase is still subsisting, admitted. Secondly, in seeking to set up a case for modification of the relevant provisions for payment of interest, the respondent must acknowledge the jural relationship between the parties. So if it wasn't there in 2012, they are acknowledging a jural. Finally, the claim for interest is a part of a wider transaction for sale and purchase under the agreement dated such and such, which still subsists, and the principal sum towards the purchase price has not been claimed back, and the same is not barred by limitation. This further evidence of subsisting jural relation. This is the clincher. So our client can now again make another application for the interest that they are still holding my principal sum and they still haven't conveyed the property to me. So that my interest is still accruing as per this award. But that is a subject matter of a different arbitration if it is. But the fact of this arbitration is that my principal sum is still with them. So till the date, till the date he has it, he has to keep on paying interest. When he returns my principal sum to me, the interest will stop. The argument on basis of limitation is thus based on a clear misunderstanding. Yes. So that ends 1 to 14 is the limitation. Now, my learned friend, I don't think cited any other case law to show that this is barred by limitation, this compound interest is not there, etc. I'll deal with their cases, but I don't think on limitation he cited many cases. He concentrated on registration.
Yes, this with
So
regard
now-
to the limitation, they have pointed out with regard to the 3 clause, date-wise, it is a barred by limitation.
Yes, but that's the thing. So now, but the jural relationship subsists till I get back my money. So my 2.5 crores is still with them and it's still subsisting. That's what it says. So even in the broader picture, the question of limit, it's a continuing right in that sense. And I have asked the interest from 2018.
Yes.
As after my letter, when I recalled this thing. Then, the second head of claim is the assured amount. Now, this is the story starts. How did I skip from 11% to 13.2%? Especially from the fact that they did not get a tenant. There's a lot of evidence on that. This is about 5 paragraphs. It's dealt with. I'll go quickly. Because registration, I just want to jump ahead a little bit because your lordship is also going ahead. The modification is the big claim. Now, my lord will just see once 683 because the most of the cases were cited on the question of registration. 683, I'm jumping to the last point. I'll come back to these other 2 points. Paragraph 34.
Yes.
The respondent's last argument, argued with least gravity, relates to the admissibility of the agreement dated such and such on the ground that the document seeking to transfer an interest in land should have been properly stamped under the provisions of Section 35 and registered under the provisions of Section 17. Neither the said contentions is tenable. First, the document has been exhibited and relied on by both parties without any objection from either party at the outset. Secondly, the agreement of 31st December itself provided in clause 11 thereof that the parties would enter into a formal agreement for sale subsequently. Hence, Section 17 of the Registration Act is not necessary to have the said agreement registered to be admissible. This is the bigger point. That other one is a defense that once it's gone in, the document is there. But I'll stick to this point. Like I said, what is the nature of the agreement? It does not require registration. Then that whole thing falls flat. And they seriously have not taken this point in the 34 at all. My learned friend said it's a point of law.
They filed an application, I think so.
Okay. They filed an application before the arbitrator.
Correct.
And after they had given their written their objection, after it had gone in the evidence.
No, I think they pointed out
I'll show
it will be decided. It will be decided.
No, then he didn't press it. We were all there. Then he said that no, let it be decided along with the final.
Correct.
So this is what has been decided. But also, yeah.
No,
If
that's
it
why
was-
if he filed an application with regard to this aspect, the paragraph 34, neither the said contention is tenable. The first document was exhibited, relied on both the parties without objection, but he has raised the objection.
He raised the objection afterwards.
When the document
I'll
was
show that,
exhibited, when the document was exhibited, and when they filed the
Yes,
objection.
when I come to the evidence, I'll show. And that's specifically recorded in that minutes that their counsel agreed that these documents are admitted documents. And it was marked by consent, literally. Thereafter, my lord, there was a change. Then Mr. Sen came and he made an application, but knowing that the application would normally be under section 16 before you give your defense.
Correct.
But this was given long after.
So that's why I'm asking. If it is
but,
filed,
But
if it
then
is-
the arbitrator said, very well, he said, we'll consider it at the time of hearing. And then it was not argued at all at the final hearing because it's recorded here with least gravity. It was mentioned, fine. But the whole thing is that if the second point holds on the face of the record under clause 11, if there is no agreement for sale today, then this agreement doesn't transfer title, and I am also not claiming that it transfers title. In the argument, he showed one part of the evidence where our client has said, yes, I have rights under this agreement to the flat. The layman will obviously think my booking allotment is a right, but it's not a right of property as such. That which requires registration. Otherwise, every time you walk into a developer's thing and say that I'm interested in allotting a flat, then that document has to be registered straight away before any agreement for sale is entered into. Okay. What? What? Yeah, okay. So the dates, I would come, I just jumped to this to show that he didn't argue this before the arbitrator, and because the other 2 points will take a little bit time. My lord, the application they made was filed on 15th January 2020, page 175, volume 2. Just for your lordship's noting, keep it, I will put it
Page 175, volume 2.
Page 175 is the jurat part. That's the date they've signed it. 15th January 2020.
171 it starts.
It starts at page 171. It starts at volume 2, begins with that.
2020, yes.
And that time it was also mainly
when the evidence was led.
Yes. Now the evidence was much prior to that in 257. Your lordship will see. The fourth sitting, 13th February 2019. This is after counter statement, then issues, then the evidence. 257, same volume, 2. Where's the part is records the thing? Yeah. Where is the document?
Where is the document exhibited?
Yeah,
In the affidavit of evidence 170.
no, there's a recording. No, there's a minutes of the fourth sitting. It's recorded. I remember that.
Yes, he has relied on this. To show that he has relied.
The deposition I pointed out 257. It was proved on that day. It was in my affidavit evidence. But I'll show the part where exactly this document is exhibited. There's no objection. That is recorded.
That is the main crux. Because arbitrators are not decided. Arbitrators are not decided that application. If it is after that, there is no issue. If it is before that, there will be some issue on that.
I'm saying there's a minutes where he's recorded that these documents have been exhibited and they haven't objected to it. Yeah. I'll just take it out. I just remember from my memory, but I've just maybe look at it. So this issue would be important again, because if this document was registrable and was stampable, then it would be important that it has gone in under 35, you can't take that point now. But if we are correct on the second point, that this agreement is an investment agreement which doesn't require registration at all, then there's no point also in going into that. That's what I'm trying to say. This is a much. So I had to take the option. I take the option, the second option, and I'll deal with that, of course, because my learned friend has cited at least 3 decisions on when Section 35 will come into play.
Yeah, that's
and there is also a latest one judgment that even in spite of all that, stamp is like God, which is like, and the previous stand, like when we began, we were told that council never takes stamp point because we are not revenue collectors. We are interested in what's the merit between. But now Supreme Court has held that it's compulsory. But luckily, SMST, while they took this point before my lord, I think we spent at least 3-4 days arguing this. That judgment came and then global, so that point is conceded. But only thing that remains is that even then, can you look into this document? Even if the arbitration agreement is considered to be the black box which survives the agreement as a separate agreement, then. So now what remains for me, if my lord comes back to 671. So what I am trying to do, usually I would not place an award, but this every point they have raised has been answered by the arbitrators. That is what I'm saying. And
how far the court gone?
Yes, how far? Then I'll rely on Sang-Yong and all these, the usual cases, and give my lord. So, can I continue?
That is the two law point here with regard to the whether it is a compoundable interest, continuation of the interest. So limitation gone, and with regard to the section 35. These are the two main points. They are
regard to the section 34. No.
30, no,
this
registration. These are
17.
These are the two main point, and with regard to the calculation and all these things, that is our
calculation will work itself out, I hope. But once the liability is there, but the other
and calculation, the third is that you have given the calculation subsequently. They have
no, but the arbitrators have recorded. They were also to give, and it's a part of the thing.
Sitting minutes, he only objects from CD 10. At CD 2, he did not object, so that went directly.
Yes. If my lord comes to 695, this was the minute. Yes.
That's
5.
695. Volume 5. Today, the claimant has produced its witness, Pushkar Raj Kaushik, whose affidavit of evidence has been filed today, 695.
Yes.
But this affidavit of evidence is at page 178, 179 of volume 2. And I'm just telling my lord that this agreement was tendered as CD2. That's the only important thing my lord needs to know. Then before examination of the witness, Mr. Banerjee, learned counsel for the respondents, informs this tribunal that on instructions from his client, he does not admit the correctness of the following documents in the affidavit evidence. These are CD10, CD11, CD16, 17. These are all the charts, not CD2. That's what I'm trying to say.
CD2 is the agreement.
CD2 is paragraph 4, page 180 of the affidavit evidence is at page 180, paragraph 4, CD2 was done.
from 117.
So, Manoj, those
yes.
few documents I asked, because evidence and affidavit was there, those few documents I did an examination in chief and proved them again. Who's prepared this document, etc. So I had to do that.
So this is on 13 February 19. 13
February 19. And the application was made a year later.
Okay.
That was a year later.
Yes.
Well, shall I do the other two claims tomorrow? The modification and the assurance.
Come tomorrow. Census occurring for the petitioner. Census occurring for the respondent. Counsel for the respondent has argued it means,
So these are the.
but due to possibility of
Okay, what is-
hearing could not be completed. Let the matter appear tomorrow. कल भी 11:30. Let the matter appear. Tomorrow also fixed. Let the matter appear tomorrow. 11.
কোন ডেটা?
এটা তোমার
এটা এটা সত্য।
হ্যাঁ, চল। এটা আমার
Thanks for the
চলে গেছে
grateful.
পরে দেবো।
Yes, next.
I appear for the plaintiffs.
Yes.
This is for money arising out of a post-production of a movie. If the plaintiff's witness action is over, the defendant is to lead their evidence.
Who is for the defendant?
Mr. Shoroshi was appearing for the defendant.
Witness action. Your witness was cross-examined.
Lordship, it was also re-examined.
Shoroshi Dasgupta.
Shoroshi Dasgupta is the counsel appearing. The Lordship can fix a date for filing
But they
of
will
the...
not come. What will happen?
Lordship, I shall communicate to the advocate on record.
So and so appearing for the plaintiff. None appears on behalf of the defendant. It is fine from the record. The case is fixed today for witness action on behalf of the defendant, but none appears on behalf of the defendant. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on. Give the date. Witness action. 25th August at 3 p.m. for witness action of the defendant. The counsel for the plaintiff is directed to inform the next date of hearing to the learned counsel for advocate on record of the defendant, so as to enable the defendant to take appropriate steps.
Great.
Next.
I am the respondent number 1 in this GA.
My lord, I am the petitioner in this case.
Mm.
Due to the demise of advocate on record, we need to file a fresh wakalatnama. So I seek an adjournment for this case.
What is the stage?
My lord, this is basically, I'll just indicate, this is basically an old suit filed in 2018. It was filed in the ordinary original site.
Correct.
Later on, they got it transferred.
Mm.
Now, the original defendant that they had arrayed as a party had merged into me. I am the new company. So they figured it out late, and now they have made me a party. Now I have come in. The court has accepted me as a substituted party. The court has even transferred it to the commercial side.
Correct.
The only issue here is, my lord, and I want to put my learned friends on the other side on a formal notice. They have to take steps according to chapter 3 if they wish to. Otherwise, I'll take steps in accordance with law. Because now it's under a suit under the Commercial Codes Act, and I have my rights under the Commercial Codes Act, under chapter 3.
So what is the stage now?
So the stage is now they were supposed to serve the amended copy after amending it to the commercial courts.
Who is the plaintiff? You are for the
Yes.
plaintiff.
Which they haven't done yet.
You're not done the amendment. Amendment is carried out.
Amendment has been carried out,
Yes.
but the amended copy has not been served on me.
You filed the written statement.
No, we have just the amended copy has not been served on us.
No, with regard to the initially you filed the written statement.
No. We were not a party.
Achha, you are not the party. Now you are.
It was at the old company which has now merged into.
What is your name now?
My name now is
IVL
Dhansari.
And what about the defendant number 2?
The defendant number 2 is a different agent. He had appeared.
What about the defendant number
previously.
2? He is not appearing for the defendant number 2.
No, I am not appearing for defendant number.
And when this defendant number 1 was added, 19th August 2020.
This was, my lord.
19 September.
Yeah, 19 September.
19 September of
2024.
No, actually, I see my presence on 19th August itself.
You not received the copy after the amendment. You have been made a
Not
party.
yet, not yet.
Yes, madam.
Yes,
what are you doing?
we are not. I don't think we've been formally added as parties yet. They have to serve it.
Party has been added.
Yes, but they have to serve the.
ये मनुतोष ये amendment कब हुआ?
My lord, the
24.
19 September 2024.
Merger with the defendant number 1 with the entity, therefore substitution is prayed for. Defendant did not raise any objection. Let A to I of the master.
Now kindly take 4th December 2024 order, my lord. They were given a direction to file the amended written statement and serve it on us, which possibly hasn't happened yet. আমি মামলা করছি না চিন্তা করবেন না
My lord, the advocate on record is demise. So
হ্যাঁ আমরা মামলা করছি না. I'm not asking for any prayer. হ্যাঁ
So and so suffering for the plaintiff. So and so suffering for the defendant. It is found that the suit has been transferred from the regular division to this court, and subsequently the plaint has been amended and defendant number 1A has been added in place of original defendant. Counsel for the defendant number 1 is submitted after the amendment of the print. The copy of the print has not been served upon the defendant number 1A. In view of the submission, will you accept the copy?
No, not yet.
1A. Now you will accept, then I will dispense with.
Accept if they serve it on us, I will.
It's out.
my lord will serve the copy after
Don't know
that.
anything. She's only appearing. क्या बोला? Submission made by the counsel for the respective parties, the plaintiff is directed to serve the amended copy of the plaint along with the document to the added defendant being defendant number 1A within a week from date.
My lord, only other thing, just one thing, my lord. I want to reserve my right to take action under chapter 3. So let them be put on formal notice. If my lord kindly records that.
What?
That whether they want to apply for pre-mediation, pre-litigation mediation.
They are not applying. Why the court will write all these things?
My lord, later on they will come that this is a transferred suit. I need not have done it.
Not done it. Not done it. Let the matter appear on 3rd July 2024. Because they have sent one advocate, she don't know anything.
So that's why I was hoping if it is recorded
Why the court
in the formal order,
why the court will give all the suggestion to the plaintiff? Do this, that, do that.
It helps me, my lord, as a defendant. It protects me.
The court cannot direct the plaintiff. Yes, next. Yes. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter be placed in the list of in the warning list. Next.
I appear for the plaintiff, my lord. This suit has been placed under, my lord, the undefended suit, my lord. I shall produce my evidence, my lord, and file my affidavit. My lord,
where is the affidavit?
My lord, today I don't have it, my lord, but it is otherwise ready, my lord, on the day.
Till November 2024 is taking.
No, my lord, it is ready, my lord. My advocate.
That's right. Since September, the case has been transferred from the original division to this court. Then 20 November, 27 January, then 12th March, now up in June.
No, my lord, what I am praying, my lord, will kindly fix a date and time. My witness will come along with, my lord, the issue.
So suffering for the plaintiff. Counsel for the plaintiff prays for time to file judge's brief of document and affidavit of evidence.
Subject to correction, judge's brief probably fine.
Yes, I'm fine, and judge will cut it in to file affidavit of evidence. Full stop. In view of the submission made by the counsel for the plaintiff, let the affidavit of evidence be filed within 3 weeks from date. List the matter, give the date. 26th of August at 2 p.m. for witness action.
2 p.m.
Next.
Great. In this matter, I'm appearing for the plaintiff.
Yes.
My lord, it is a transferred suit, my lord. My lord, I'm yet to file the statement of truth and my lord, the list of documents. I was seeking, my lord, 2 weeks time, my lord. I would have done it earlier. My client is out of station, is coming back after some time. So, my lord, kindly grants me 2 weeks time. I'll, my lord, comply with the...
Princess when appearing for the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff prays for time to file statement of truth, affidavit of documents, and compliance of other formalities under the Commercial Court Act. Other formalities under the Commercial Court Act. In view of the submission made by the counsel for the plaintiff, case is adjourned. In the case is adjourned, let the matter appear on 22nd July 2025. In the meantime, the plaintiff is directed to take appropriate steps.
I'm extremely grateful to my lord.
May it please your lordship, appear for the plaintiff.
Well, I am for the defendant, my lord, petitioner, my lord, kindly take this matter, my lord, next week, my lord. The evidence are complete, my lord. Kindly take it up for hearing on the next week, my lord.
Yes, GA3.
Yes,
What is the GA3?
My lord, it's an amendment of the written statement, my lord. Kindly, my lord, evidence are complete, my lord. Kindly take it up next week.
Complete. Why you are not arguing the matter?
My lord, next week, my lord.
Let it go to November or December.
No, my lord, sometime, my lord, only some difficulty.
Okay, I am fixing in the month of after Puja vacation.
No, my lord, next week all.
Next week my diary will not permit. What will do?
Not only sometime, my lord, there's some difficulty, my lord.
As per the prayer made by the counsel for the plaintiff, you are for the defendant.
Yes, my lord, I'm the
As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear in the combined monthly list of September 2025.
26, I appear for the plaintiff, my lord.
Yes.
My lord, a report was called for, my lord, on the last date by your lordship from the, my lord, department to ascertain, my lord, whether, my lord, if against defendant numbers 3 and 5, my lord, writ of summons was, my lord, lodged or not.
I appear for the defendant number 3. We have taken out an application GS6, my lord. It is not. May I indicate that on 27th of March, my lord, the writ of summons was issued, my lord, and the plaintiff, my lord.
You are appearing for?
Defendant number 3. I am for the defendant number 1, my lord.
রিপোর্টটা ছিল না
অ্যাপ্লিকেশনটা তো বুঝছি
My lord is seeing the order of 6th of May. Report. ওই অ্যাপ্লিকেশনটা করছে না তো কেন তো কি ছিল
Yes. So defendant number 2 and 5. Writ of summons was served through the postal services.
And
on 7th May 2025, on 8th May 2025.
Then, my lord, service is otherwise complete.
The writ of some through the district judge, it could not be. It has not been returned. No report has been come. But with regard to the postal services, item delivered on 7th May and 8th May for the defendant number 2 and defendant number 5. And defendant number 1 has already entered appearance, 4 entered appearance, 3 entered appearance. Only defendant number 1 filed a written statement.
Yes. So, my lord, today, my lord, this order was passed on my application GA5. Others, my lord, defendant number 1, 3, and my lord 4. The, my lord, issue of, my lord, filing of written statement, lordship had already, my lord, captured it in a previous order. It was only for defendant number 2 and defendant number 5 that this order was passed. Now the report lordship has indicated says that it has been served. So if they take steps, my lord, to file, my lord, within the time.
No, there is a time.
There is a time. So, my lord, my application, my prayers were in GA5, which lordship was considering on the last date.
Yes. So what about the other defendants?
My lord, 1 has filed a written statement. Now 3 has taken out an application which is not on board today in the list today. That is for extension of time to file a written statement.
Lord,
that application is not listed today.
And what about the 4?
My lord, 4 lordship has already, my lord, recorded that it will be ex parte against 4. There is an order to that effect. Order filed dilo de.
Yes.
My lord will kindly see the order of 25th of March. Yes.
According to suit against the defendant number 4, we proceeded
undefended. So 4 is also, my lord, taken care of. Now 3 has taken out an application. I don't know whether 2 and 5 after service of summons, whether they will, my lord, participate or not. 30 days time, my lord, the date which lordship just now indicated is over. So if they have to file, they have to take, they have to apply.
we have taken out an application. The application is not on board today. And there's a delay of 55 days. My return statement
for
defendant number 3. My return statement is affirmed and ready. The copy is also here with me. If my lord
received the writ of summons.
Well, I have received it on a copy was served upon me on 27th of March 2025. Subsequently, what happened, there was a miscommunication. I apologize, whatever has happened, we and my staff, due to that, we made a fresh notice to the plaintiff to comply to my lord's order. Going to that, a fresh notice was served upon us, indicating that on March they have already served us the copy. We went on in our office, was searched out, we found out that yes, a copy of the plaintiff was found. Immediately, we made the written statement ready, and it was affirmed on the reopening week of the after the vacation. It is affirmed and ready. It is on board. If my lord directs me, I can serve it today itself.
My lord, it is within 120 days. That is correct. But the, my lord, paragraph 2, he says that he has first come to know about the suit from, my lord, service of summons. That is incorrect because there is a prior interlocutory application.
My lord, I was contesting while the application was there. GA1 at that point.
It's better to have a, my lord, defendant than not to have a defendant. I realize this one. I leave it to my lord. Treat this application as on days list and my lord disposes it.
What is the number of the
It's GA6. GA6, I can hand over a copy of the application to my lord right away.
My lord, I can give my copy, my lord, it's unmarked.
It is filed.
It is filed, my lord can.
I'm not accepting the, my lord, averments in the application because those are not correct. But we understand it is within 120 days from the date of service of summons.
Yes, and this is with regard to defendant number 3.
Only defendant number 3.
And 4?
4 is ex parte.
1 and 2?
1 has filed.
1 filed. 2.
Now 2 and 5, my lordship indicated from the report that 30 days is over. If they want to contest, they have to come and apply.
Okay. The last direction was to serve upon the defendant number 2 once again for taking steps.
That is served. The report is there.
Report is there.
So and so appearing for the plaintiff. So and so appearing for the defendant number 1. Defendant number 1?
1, my lord.
1. So and so appearing for the defendant number 3. And nobody's full stop. The defendant number 3 has filed an application being GA6 of 2025, praying for condoning the delay for filing written statement and for acceptance of the written statement. counsel for the defendant number 3 submits that the writ of summons and the plaint along with the document, the writ of summons has been is received by the defendant number 3 on 27th of March 2025. 2025. Full stop. Accordingly, the plaintiff has, according to defendant number 10, learned advocate appearing for the defendant number 5 has filed the written has filed wakalatnama and entered appearance. Full stop. He submit that for preparing the written statement, comma, the defendant number 3 has directed the defendant number 3 for bringing the documents, due to which 30 days for filing of the written statement was over, but the written statement has been prepared and affirmed on when you affirm the written statement.
My lord.
When you affirm the written statement.
11th of June. 11th of June.
On 11th of June.
Lord, may I indicate there is a counterclaim also.
11th of June 2025, along with the counterclaim, and the written statement is ready. If along with the
court fees, if there is a counterclaim, there has to be.
That
the fee has been
period of within the period of 120 days, along with the contract. Counsel for the defendant submits that non-availability all the documents with the defendant number 3, the written statement could not be filed within the period of 30 days, and he prayed for acceptance of the written statement. Learned counsel for the plaintiff raised objection and submits that they have received the written copy of the print along with the document, and they could have been filed the written statement within the period of 30 days, but they have not shown any reason as to why the defendant number 3 has not filed the written statement within the period of 30 days. He prayed for rejection of the application. But the learned counsel for the respective parties produce the materials on record. It is find that the defendant number 3 has received the writ of summons on 27th of March 2020. Admittedly, the defendant number 3 has not filed the written statement within the period of 30 days, but has affirmed the written statement and the written statement is ready with the counterclaim within the period of 120 days. Considering the above, this court find that one opportunity should be given to the defendant number 3 to file written statement along with the counterclaim by tomorrow.
But the copy will I can hand over right now.
No, when you will file.
Department file kar dega.
But today itself.
No, I think the order would be necessary.
But tomorrow then will.
By आज कितना तारीख है? 17 है ना? By 19th of June 2025, after serving the copy to the learned.
Let me hand over a copy to the.
After serving the copy to the learned counsel for the plaintiff, subject to payment of cost of rupees 2,000 to the State Legal Service Authority within a week from date. In view of the above, it's GA number 6 of 2020. Week from date. By 19, the amount will be
GA6 may be treated as on days list and Malad disposed.
Though the GA6 is not listed today, has been treated on the days list and is disposed of.
Grateful. Malad, now Malad, so far as GA5 is concerned, the application in which the order was passed, this really nothing survives, my lord. Kindly comes to my lord the master summon to the my lord notice of motion once, my lord. Lordship has already prayer if I wanted a declaration that it is undefended against D3 and D4. Now, my lord, defendant number 3, Lordship has allowed written statement. And D4, my lord, Lordship has previously set it ex parte against defendant number 4. And defendant number 2 and 5, we will await, my lord. If they take any steps, my lord, let them come. Otherwise, it will proceed, my lord, against them undefended.
The plaintiff has filed another application being GA Com 5 of 2025, praying for fixing the suit against the defendant number 3 and defendant number 4 in the list of undefended suit. Defendant number 3 and defendant number 8, as well as 2 and 5.
My lord, only 3 and 4 undefended. 2 and 5, I wanted to, my lord, effect substitute service and come back.
As regard the defendant number 2 and 5, prays for substituted service by inserting publication in the newspaper. This court find that before taking up the matter being GA5 of 2025, this court has disposed of GA6 of 2025, wherein the defendant number 3 has prayed for extension of time to file return statement, and the said application has been allowed and return statement is accepted. Accordingly, prayer with respect of defendant number 3 has become infractuous. As regard defendant number 4, this court, by an order dated
25th of March.
25th of March.
Order dated 25th of March 2025, already passed an order by placing the matter in the list of undefended suit against the defendant number 4. Accordingly, prayer against the defendant number 4 also become infractuous.
My lord, so far as the report which has come forward so far in respect
As
of
regards
D2
the
and
defendant
D5.
number 2 and 3, this 2 and 5. 5. In compliance of the order dated 6th May 2025, the registrar original side has submitted the report dated 16 June 2025, wherein it reveals that writ of summons along with the plaint and the document were served upon the defendant number 2 and 5 through speed post through the postal services on 7th May 2025 and 8th May 2025, and as such, full stop 2020. As the writ of summons has been duly served through the postal services on 7th May and 8th May 2025 to the defendant number 2 and 5 respectively, thus there is no necessity for passing further order for publication of the notice for service of notice upon the defendant number 2 and 5. Accordingly, this court did not find any justification for passing any order for publication as prayed for. In view of the above,
My lord, also makes it clear if they, my lord, don't, my lord, approach within the statutory.
as the writ of summons has been served upon the defendant number 2 and 5 on 7th and 8th of May 2025, but till date the defendants have not, defendant number 2 and 5 have not entered appearance. But this court find that the defendant number 2 and 5 having time of 1/20th days to file their written statement. If they will not file the written statement by the time fixed within a 120 days after receipt of the writ of summons, appropriate order will be filed.
Great.
In view of the above, GACOM 5 of 2025 also disposed of.
May we have a copy of the report of 16 June of the, my lord, registrar?
The copy of the report of the Manutosh, the copy of the report of the registrar dated 16 June 2025 be served upon the plaintiff, on the advocate on record of the plaintiff. Let the matter appear on. So now your written statement is accepted. Now you have to file the written counter claim.
I have to file, my lord, a additional written to the counter claim.
Counter claim, and
My
there.
lord, will your lordship provide for that also here in the?
No. As per the division bench judgment, after correction, then you will be in difficulty.
Very well.
You will be in difficulty.
We will start the process and we'll apply if required.
Then, my lord, the matter is made returnable sometimes, my lord, after September.
No, these two applications are disposed of now.
Because 120 days will be over May.
May, June, July, August, September.
So, my lord, after September, after Puja vacation.
Let the matter appear on 11th September 2022.
My lord, I would pray, my lord, kindly considers this. As a plaintiff, my lord, I have a, my lord, right to persuade the court to take it up beyond the period of 30 days if there is no written statement. Now, I cannot anticipate that. So, I want, my lord, since my suit is pending, I would, my lord, kindly not keeps it in September. We will mention it. We want an expeditious.
But you come with your written statement.
I will.
Then
And
you
then
mention it.
So, my lord, okay, lordship will then prepone it.
Then we'll see to that.
Grateful.
Next.
Well, may I take back my application or will it be there?
Take back. उसका application दे दो.
Yeah. Lordship,
Yes.
kindly allow my junior to move the matter.
Yes.
Yes, your lordship, this is an amendment application
Yes. Who is for
to the execution.
decree holder?
Yes, your lordship. I'm
What
for
is
the
the
decree
amendment
holder.
you have paid for, madam?
Yes, your lordship. In the master summons, I've prayed for an order directing amendment of the tabular statement and the affidavit in support of the tabular statement, your lordship. Your lordship, if your lordship comes to page number 15 of the application.
Let me see what is your prayer. Directing the amendment of tabular statement and the affidavit in support of tabular statement in the manner indicated B. Paragraph page, where is B?
Yes, your lordship, only the date of interest from which interest
Where
will be accrued was not mentioned. Column 7, page number 15, your lordship.
15.
Yes.
Added interest calculated at the rate of from 9th March
12%
2014
from 9th March 2014.
to till 31st December 2014.
Yes, Your
This one.
Yes, Your
And next one.
And Your Lordship, page number 19, paragraph 8. In the affidavit in support of tabular statement.
19. Paragraph 8. Interest calculated. 9th March 2014. Why the 9th March 2014 has come? Where is the decree?
Your Lordship, kindly comes to the page number 11 of the application. That was the date of first invoice. Your Lordship. Page number 11.
Page number 11.
Yes. Bottom. Continues to page number 12.
9th day of March 2014. Okay. Census and suffering for the decree holder. Decree holder has filed the present application being GA-Com 1 of 2025, praying for amendment in the tabular statement and in the affidavit, tabular statement and affidavit in support of tabular statement. Consider the submission made by the counsel for the plaintiff, peruse the amendment as sought for by the decree holder. This court find that the amendment as sought for the plaintiff decree holder is formal in nature and will not change the nature and character of the application. Accordingly, prayer cannot fix the time. Prayer is allowed. A of the master notice of motion and master summon is allowed. Police of the department is directed to make necessary amendment in the tabular statement and the affidavit of the in support of tabular statement within 2 weeks. 2 weeks. 2 weeks from date. After the amendment is carried out, let the matter be placed before this court on 16th of July 2025. GA number census disposed of.
But before Your Lordship takes up the 1 p.m. matter, Miller, item number 28 is wrongly appearing today.
Why?
So it was supposed to appear on 27th for framing of issues, 27th of June for framing of issues. In the interregnum, Miller, discovery and inspection. But I was most humbly beseeching for a further extension of a week's time.
Come on that day, come on.
Very well.
27, huh? Yes.
Look, this is an application in connection with the probate proceedings. But only for the purpose of protection and preservation of the estate. It's a registered will. And my lord, the property of which we seek some protective orders, that's a part of the will itself. My lord, your lordship will find I think the will, the probate application forms a part of the application. My lord, if your lordship will take the probate application and come to internal page 10 where the will, it's a registered will commences. And thereafter, if I may just trouble your lordship with one internal page 5 of the will, towards the bottom, your lordship will find the description of a property. And
Yes.
thereafter, if your lordship turns to the next page, your lordship will find it describes a property which comprises of an area in excess of 4.45 acres.
4.4571 acres, yes, total. In total.
In total. That's a substantial part of land and it's in the district of Nodia. The question is that, my lord, it has a huge water body inside also. The boundary wall are substantially damaged. But the entire, my lord, the apprehension is trespass. My lord, the deceased was a retired, my lord, Indian Administrative Service officer. So, my lord, and man of substantial repute. Now, what has happened, your lordship can understand after his death, my lord, the we have sufficient reasons to apprehend that there will be an attempt to trespass. Somebody will come and say, I was living here for the last so many years. So then, Malad, that will get into a Malad, protected litigation. Malad, in order to avoid that, Malad, what we seek is that Malad, allow the executor to make a complete inventory of this property. That's all. With the assistance of a surveyor, empaneled surveyor, he will measure it, make an inventory of what is there, and Malad, and to post security guards, which is absolutely necessary. In order, some security guards are necessary to protect this property.
At present, what is the situation of the property?
Well, property is empty. Property is vacant.
When he died?
Malad,
2014. After
the
that?
6th of March 2025.
This is died 11 June. Achha, no, 11 June is the will.
Is the will, my lord. 2014 is the will. Well, your lord, you will see the death certificate is the first annexure prior just immediately before the will.
(2005) 25,
Yes.
March 25.
Yes. 7th March 2025. He died in Calcutta itself.
Died in?
In Calcutta, in Medica Hospital. In Calcutta.
Yes.
So under these circumstances, certain protective orders are absolutely necessary.
But who is the legal layers? Who is he?
Well,
the executor?
No, I'll tell you, Lordship. The executor is the son-in-law. If your Lordship will see, if your Lordship will kindly take once the application.
How many legal layers?
And my lord, kindly turn to
Married daughter, son.
Yes.
Any affidavit filed by the legal layers?
No, my lord, son and daughter. The beneficiaries under the will are the granddaughters. That means the daughters of the daughter. And my lord, the son is there. And my lord, the will records that the son's consent has been taken. The son has no, if your lordship looks at the will, one paragraph
Whether
of the
he
will.
has given a separate, along with your file, the consent?
No. He
Affidavit
has not. He
consent?
has not. He has not.
Then?
He has not given a consent. It doesn't matter, my lord. It's a registered will. Whether he does or not, my lord, citation will be issued in the usual form.
No,
He has a right
with
to
regard
object.
to hearing. So whether the son is in the property?
No. But even if he's in the property, sir, assuming for the sake of understanding, he's in the property. I am not disturbing his possession. What I am saying that the possession, I mean, the property needs to be protected. The property needs to be preserved. That's all that I'm saying. I'm not asking for any order for any legal heirs or any persons to be dispossessed. So, what needs to be seen is what is there, a complete inventory, that is necessary. And in any event, your lordship is aware, under section 193, 194 of the Succession Act, curator can be appointed.
That's correct. If the son is there and this court without hearing the son, if any order is passed, he will.
No, my lord, if your lordship looks at the will,
that's why.
Looks at the will gives the detail about the property. And this is the property in Nodia. And the son, I am told, lives in the city of Calcutta. But kindly take internal page 5 once. This is the registered will of the deceased. But kindly take the middle portion of where the 3 names of the daughters are given. They are all majors now. At the time of the execution of the will, 2 of them were minors. Now, my lord, immediately thereafter, my wife expired such and such thereafter. I am very happy that my son such and such, whom I had long back gifted my own house, property and such, and who is presently not married, happily agreed to bequeath this property to my above named 3 granddaughters. Your lordship found that, my lord. So this is the deceased in 2014, been a retired IS officer has recorded. So, my lord, considering that, my lord, even, my lord, if your lordship is of the view that if the son is there, nobody's possession has been disturbed. We say that, my lord, security guards, a complete inventory of the property, and my lord, a report to be filed before your lordship what is there in the property. Because valuable trees are there, my lord, we are told, my lord. Each tree, as your lordship is aware, is no more valuable than gold today. Some of these precious tree, and my lord, this was one of his pet projects, my lord. He has, over the years, my lord, this was like a farmhouse for him. So
move before the regular court.
No, my lord, this protection is necessary because I am not going into the detail. Why, I'll tell you,
One
lordship,
week,
my lord.
1 week.
I'll tell you, lordship, my lord, allow me to switch off the microphone. বন্ধ হলো English ও লেখা আছে। Nodia, Nodia, my lord, district of Nodia. Fine. My lord. Great. Obliged. Great.
Lordship, with regard to item number OCD 29, Lordship. Lordship, I'm for the defendant, Lordship. I'm praying for 1 week adjournment because, Lordship, item number OCD 29, Lordship. Our affidavit of admission and denial could not be filed because.
Lord, item number 30. What matter? Lord, we have taken a step. Lord, kindly come to. They did not take it.
My lord, I am for the defendant, my lord.
Body of documents. We have given notice to them.
My lord, actually, they have stated the list. They have sent me list of documents, the 30 document. They allege out of 30, 27 are lying with us. Actually, we are trying to find out the document because without the copy of the document, we can. My lord, actually, very old file. No, they have not
So
sent
we
me
have
document.
disclosed the
No.
documents. We have
Disclosed
given
it,
the
but
yes.
there are some document without date. Without
No,
date,
no.
how could I find one? Actually, my lord, some files are lying in Cochin, some files are lying in head office. I prayed for 2 weeks time. No, my lord, because
No.
my document is not ready as yet. No, no, my lord.
They did not write any letter even.
Yes, my lord, but they have not written me date. So my confusion.
Lord, we are holding those documents. We have disclosed those.
Yes, for framing issues, but actually I'm trying to take out the both at a time.
Yes.
This Friday, my lord. This Friday, my lord. It will take, my lord, allow me 2 weeks time to arrange document, my lord. Because, my lord, very old file. I am trying to that matter has been. Actually,
But my claim is repudiated for which we came. Yes, yes.
Actually, this is
This
the
is
fact.
happening.
This is the actual fact. So, this is my,
yes.
my lord, I will complete with the inspection by Friday and allow me 2 weeks time. My lord.
Then as per paragraph 5, do not extension be made, including the issues to be framed. And also affidavits, my lord. Affidavits, admission. And suggested issues also. Lordship, Lordship. I am deeply, Lordship, I am deeply.
Great, my lord.
by the trade unions of West Bengal. We wish to move a suit as well as the injunction application tomorrow if my lord kindly grants the leave. Suit has been filed, but subject to leave the suit as well as the injunction applications. The urgency is that a pharmaceutical medical giant, your lordship has considered these kind of situations in an earlier matter, Abbott Industrial, where I only appeared. In this case, another pharmaceutical giant has been restrained, and this is being going every day, as we speak. It's still happening, the representatives are being restrained. If my lord may kindly grants leave, I wish to move it tomorrow, I'm being it's there, your lordship is just the advocate on record is coming, with the original suit, the suit has been filed, only number will get it by tomorrow. I'm being led by Mr. Dhruva Ghosh, kindly keeps it at 2 p.m. tomorrow. Your lordship, I'll just give this one. No, it's very urgent, your lordship. Otherwise, I wouldn't have mentioned at all. 2 p.m. tomorrow. Your lordship, otherwise, I wouldn't have mentioned. If the matter could have waited, I wouldn't have troubled my lord. Since this is an urgent determination, that is my lord. But some indulgence, blood. It's a very, very high stake matter. But it shouldn't take more than half an hour. If my lord takes not more than half an hour, blood. If my lord keeps it at 2, blood. Lord, may kindly 19th at 2 p.m. The plaint as well as the injunction, I shall give the I am here, but the advocate on record is still on. Kindly that leave, I shall give the plaint as well as the injunction. Yes, just in us. I shall give just in the course. Extremely great.
My lord, I am for the plaintiff. Mr. Banerjee was making his submission.
My lord, Mr. Banerjee is in this matter. He's coming. I'm just starting reading the agreement because last date your lordship was saying that was considering that this agreement is vital. So I'm just reading the. Yes, sir.
There is nothing in the matter, my lord. I don't know how that agreement, which my learned friend is also reading out, is important or not necessary, because the matter has, for all practical purposes, ended. A special officer should be appointed to calculate mean profits. If I get it, I get it. I don't get it, I don't get it.
Mr. Banerjee is coming here, stuck in the somewhere.
No, my lord, what Mr. Banerjee just mentioned to your
Conveyed.
lordship, on his way, his car has been hit by somebody. So there is a chaos on this process, and since there is a fixed matter, Mr. Banerjee since wants to place the agreement. He mentioned, we just continue with the agreement. There is a no termination clause that yesterday already mentioned, and he will continue.
Shall I start? This agreement made 7th day of May 1000. This one. Judges brief of documents.
Page 1.
From page 1. This agreement made this 7th day of May 1984 between no, my lord is which my lord, our contention is that this agreement does not contain the termination clause. So if I have to show that it has a termination clause, then I could get into directly to that point. But I have to show that the whole agreement does not contain the termination clause. That is why I have to read the whole agreement to show your lordship, to satisfy your lordship that there is no termination clause. Upon determination of tenancy and delivery of vacant possession of the tenanted premises to the landlord, the said amount shall be refunded to the tenant subject to such claims as the landlord may have against the tenant for the reason of failure of the tenant in performance and observation of the tenant's part or the of the contract. Now, here if your lordship finds that if there is a determination of tenancy, what will happen? But how the determination will be held? This clause is silent on this. Yes. And as per the agreement, my contention is there is no clause for determination of this agreement of the tenancy. That is why, lordship, I want to read the whole agreement. That I have to take that I have to take an instruction, your lordship. That I have to take the instruction. I have to take instruction from my senior actually. Is this agreement is for lifetime or for a certain period of time? Court is considering that matter. Yes.
The date of notice? Till the date.
Till the vacation. Well, then can the date be accommodated another date? Coming, he's coming. He's coming. He's coming. His clerk is telling. Actually, for that accident, something. Which one? Which one? Your Lordship, there is no time. What do you find? There is an increase of the rent. Which this one? From what date to what date this agreement is valid? That is from what date is there, but till what date? And come to pattern in the same page, pattern number 4, point number 6, Your Lordship. It is agreed that the monthly rent from time to time payable by the tenant to the landlord shall be increased every 3 years by 10%, and this will continue during subsistence of the tenants. Recommendation चाहिए? My lord.
I'm extremely sorry. My lord, my intention to place this document is to show how and why the parties has arrived crossed how the parties has arrived to this agreement. Because we all know that unregistered agreement is a month-to-month tenancy under 106. So my endeavor will be to show even there is a month-to-month tenancy, but the terms and condition will be governed in addition to what is written in 106. That will be my endeavor. I will try to reach there. Para 5. The tenant will deposit and keep deposit with the landlord a sum of rupees ato and ato. Already deposited, landlord shall not be liable to pay any interest thereon. The amount will be kept deposited with the landlord by way of a security and for observance performance of the tenant part of the contract as.
May I have your lordship's leave, madam, and the juniors.
So lordship, kindly take note of 5. So once there is a no termination clause, so lordship, moment there will be a termination, the money has to come back. Lordship, money, why? Yesterday when I was submitting before your lordship, I said that I handed over the possession. I used specifically a word is no complaint basis. So since there was a no complaint basis handover, until date there is nothing on the record that there was some complaint. So this money cannot be adjusted with maintenance or repair of anything. So the money may not attract interest, but yes. I will come. That's what I'm saying, lordship. So when it might not attract interest, but on termination, 2 things will happen. I will deliver him back the possession, or he will also return this security deposit to me. Now kindly see, this amount will be kept deposit with this performance of the tenant part and for contract therein after stated. Upon termination of the tenancy and delivery of vacant possession of the tenant, premises of the landlord, the said amount shall be returned to the tenant subject to such claim as the landlord may have against the tenant for the reasons of the failure of the tenant in performance and observance of the tenant's part of contract. So lordship, there are 2 parts. So tenancy will only come to an end not only by way of a termination. Termination, delivery of possession, and refund. So Lordship today, that's why I yesterday said three things very category. There was no decree suffered by us. So before suffering of the decree, I handed over him the possession. And till date, he has not handed over me the money. Therefore, the termination is not conclusive in its nature, even as of today. What I am saying is to keep this document into an end, three things: his termination, my delivery, and then return. Termination is by giving a letter that I want to terminate, then he is taking help of 106. I don't like your face. He did not to give any. But only, that's what I was trying to establish before your Lordship. Only that statute will not govern. We have decided additional formalities with that statute. So now I have to read. First step is the notice under the statute. Second is my delivery of possession. And third is refund of the money. So this agreement, yes, I have to hand over. So as on today, it has not been refunded. So not too much, but yes. Yes, yes. Yes, yes. Because I was in possession. So Lordship today, when Lordship is deciding me in profit, then Lordship, this agreement is alive. I am saying it's not the monetary claim. I am not saying about the monetary claim. I'm not worried about the money. I am trying to establish we cannot see 106 in separation to this agreement. Yes, yes. This adjustment I will get or not, it's not, I'm arguing. No, Lordship, I will show from this agreement, I will take your Lordship further detail. Only because only breach is to be looked into. The agreement, the notice under 106, every time I say that required no reasons, when only 106 is there. But when 106 is supplemented by an agreement, then Lordship, the agreement has to be seen. Yes. Yes. So it's a month by month tenancy. Month by month tenancy. But the month by month tenancy, the agreement, the terms between in that tenancy is this. So this agreement, even as of today, is not concluded. So, and then they have gone to no, suit has not decreed. That's my point. No order passed. Suit has passed no order against me. Yes, Lordship, that's the strange, peculiar fact in this matter. There is no order of eviction or no order of handing over. It is my voluntarily act of handing over. So this is not a case where I have suffered any degree. That's what I said. I suffered a degree. I set aside that degree. The decree which was obtained against me is set aside by the division bench during pendency of the trial. So today I had no degree against me. I've complied with the monetary part. So decree is not there against me. So when there is a no degree, now I have to think as if there is no suit. So the termination notice is one date and delivery of possession is another date. Now in absence of a decree and in presence of this agreement, whether they are entitled to any mean profit or not, the issue number 4 or 5 which I have shown, whether they are entitled to it. So what is their case? That I have terminated. First thing, they have to cross the hurdle that they have terminated correctly. And then if it is terminated and I have delivered them late, whether for my late delivery mean profit they are entitled or not, because I suffered no degree. So the Lordship, the issue I have framed, one issue is Lordship. Yes, Lordship. Judge's brief. Division bench order. Justice Manjula Chellilo order. কোথায় বলো এখানে মামলা করছি ওটাও তো পাঠান জাস্টিস মঞ্জুলা চন্দ্র May I place it 2 minutes late, Lordship? Give me 2 minutes time. Justice Manjula Chellure order টা আছে তোমাদের কাছে? Lordship, the order decree was passed based on oral concession given by my lawyer. Oral concession given by my lawyer. So that was challenged in the court because the decree which I suffered is also not a decree by adjudication. That was a decree by consent. Even if I go against me, so then also I will ask the first degree which I suffered is by consent. Then that consent degree is set aside by the court because there was no valid consent. So at no point of Yes, Lordship. Just allow me 2 minutes time, Lordship. I was just not ready with that document, but Lordship, I will place it. Lordship, meantime, may I continue with my. Justice Manjula Achal, order to. Now, Lordship, kindly come to para 6, the agreement. There is an enhancement call of every 3 years. And Lordship, this has been accepted by the parties and acted. Now, kindly see that tenant covenants with the landlord that the tenant shall, during the subsistence of the said monthly tenancy, kindly come to that word monthly tenancy. Now he has certain observation, certain obligation to observe. Now, Lordship, we will read the termination letter with in conjoined reading with clause 7. So this is in a monthly tenancy also, I will observe this. Now, if I observe this and now kindly come to the termination notice. Lordship, the next document is the termination notice page. My lord, may I hand over that appeals court order, Lordship? Date 17 December 2014, APOT 577. 577 of 2014. Heard learned counsel for the appellant who persistently pleaded on an adjournment on the impugned order para 2. The learned judge made it clear that what circumstances included this. The trial court was relevant time. The amount of submission regarding this was within the knowledge of the previous counsel. Stand ready to stand the degree in terms of the VR opinion that the bank guarantee the stands respondent for the above settlement referred to impugned order. By this time, the landlord would have got no defense. It is pointed out the sum of 1 crore is reported to be the registered from law. There is a termination notice in for the settlement degree in terms post of in favor of the opinion. Now, final order change যাচ্ছে না এটা টাকা জমা দেবার না যেটা আমরা জিতলাম. Then is the second order how the appeal is allowed. I'm sorry, this is the 1 crore which money I have deposited. এটা ফাইনালি অর্ডারটা সেট অ্যাসাইড করলো. দেখো অনিন্দ মিত্র সাহেব অ্যাপিয়ার করেছে. Lordship, may I hand over this? This is the final order. First I deposited, Lordship. This is Order 23, Rule 3 needs a written document. Lordship. After the appeal is disposed of in my favor. That is what we are present before your Lordship.
Hearing the suit. My lord, evidence is over. Final hearing. Yes, yes, my lord. Evidence is over. Now, my lord is finally hearing out the matter. Yes,
Yes, yes. Lordship is hearing the final argument in this. Yes.
It is however, my lord, no preliminary decree has been passed. My lord, whatever will be passed by your lordship is now.
That's what I am saying repeatedly. I have not suffered any degree. So unless I suffer a degree, yes. So Lordship, that is the thing I am saying. So I handed over the possession before suffering it. So now only claim against me what he have stated, delay in handing over the possession. Moment there is a decree and then main profit comes into. But here, delay. As I'm just presuming that he gave a eviction notice. I'm supposed to hand over in 1 month. I'm handing over in 10 months. Say. So in that case, 9 months, he is entitled to a damage, not in a form of a mean profit. Mean profit only comes once there is a decree of eviction or recovery of khas possession. So Lordship today, when they accepted my possession without a decree, can they call upon the court to adjudicate a mean profit? That is the reason why I have framed a issue whether they are entitled to mean profit or not. So the prerequisite of a mean profit is to suffer a decree. Then only court can go into and say that there was a decree, so your holding possession was illegal from date of termination, so you are entitled to mean profit and you are obligated to give mean profit. That's the court should inquire into. But when the court will find there is no decree, so then there is a delay in handing over possession. So for delay in handing over possession is a separate cause of action. That will not come under the chapter of mean profit. That is what I tried to submit before your Lordship. So this is with regard to that mean profit. Now Lordship comes back to the termination notice. Even the termination notice is correct or incorrect. So they invited the court, they kept the suit pending only for determination of the mean profit. And I said mean profit cannot be determined when there is no decree. And you voluntarily accepted that. And there is no evidence to show and suggest that after obtaining, because I cross-examined him after obtaining the possession. So now you cannot say the nature of the suit is decree, then adjudication of the mean profit. Preliminary degree, final degree. So if a suit for partition or a mortgage is partitioned before the preliminary degree, or a mortgage is released or by consent sold before the preliminary degree, can they go to the final degree? That we will try to ascertain from the law. You allowed it to happen. Now Lordship kindly come to the notice. Now notice is, Lordship will find the second document in Judge's Brief of Document, page 12 to 14. May I please? Because this notice also acknowledges the agreement. My point is, this notice acknowledges the agreement. By an agreement in writing dated 7th May 1994, made by and between our client and yourself, our client introduced you as a monthly tenant with effect from this. In respect of this portion of list containing a space such and such within the municipal limit, I am keeping as a monthly rent of this, calculated this, service charge this. It was agreed by and between the client that the monthly tenant and the rent payable by you to our client shall be increased every 3 years by 10%, and this will continue during the subsistence of the. In accordance with the said agreement, monthly rent in respect of the verse to increase every 3 months, and increment in the same monthly rent is such and such, and the maintenance is such and such. The West Bengal Tenancy has replaced by and pursuant to the commencement of the West Bengal Tenancy Act 1997, by reason of the provision of this, the same has no application to the tenant's premises. I pause here for a moment. So, this was a special character created under 1956. So, they were honoring that. Now they say by operation, this new tenancy has come, so this has come to an end. In such, you are monthly tenant of the premises, which is terminable by our 15 days expiry notice, month by virtue of this. Further, by reasons of the provision of such and such, the lease of the premises in your favor is leased from month to month, terminable on the part of this. Our client does not intend to allow you to use and enjoy vacate. We thus hereby call upon client terminate the tenancy such and such, and call upon you to deliver the possession vacate by such and such, failing which our client occupy will be starred on trespasser and shall be treated mean profit of such and such each day and such and such, such and such. So, Lordship, the essence of this is a agreement which is existing between the parties. He said by operation of law that has come to an end. Under the old act, it was possible to keep a tenancy agreement under this, and then now, Lordship, I will like to read section 106 once. Section 106. Yes. 106 TPF. বললাম টিপি একটা দিতে কন্ট্রাক্ট নয় টিপি বলেছি টিপিতে আছে তোমাদের May I read that? The duration of certain lease in absence of written contract or local usage. I stress on two words, written contract and local usage. So, Lordship, I had a local usage. I had a written contract. This written contract was month-to-month contract. Lordship, the contract which I had is a month-to-month contract, but every month we will be following these terms. That is the essence. In absence of a contract or local law or usage contrary or usage to the contrary. So, in absence of a contract, contract is there, written contract. Local law was there, or usage to the contrary, a lease of a immovable property for agriculture or for manufacture deemed to be leased from year to year, terminable on either lessee or lessor by 6 month notice, and a lease of a immovable property for other purposes shall be deemed to be leased month to month, terminable on the part of either lessee or lease by 15 days notice. So, Lordship, I have a written contract. So, clearly says 106 will apply month to month basis, and in month to month we are following this. And Lordship, there is a covenant which I have shown, paragraph 7 of the agreement, that my obligations are this. So, today his termination letter says, whatever your obligation you fulfilled or not fulfilled, but your agreement has come to an end. Now, Lordship, I will also read 1997 Act and 1957 Act and the saving clause of 1997 Act. Notwithstanding anything contained in other law for the time being in force, the period mentioned in subsection shall commence from the date of receipt of the notice. A notice under shall be deemed to be invalid merely because the period mentioned falls short of the notice specified under section with the suit expiry of this. Every notice under must be in writing, signed or sealed on behalf and sent to the parties who is intended to bound by it and tenant personally to such and such, such and such. So, Lordship, the very act says if there is an agreement, if it is not registered, it has to be a month by month, but that written terms and condition is to be followed. It cannot say whatever your terms and condition, like 1997 Act, whatever you agreed, statute do not recognize. So, moment the statute stands, that goes away. But 106 is not so. 106 still recognizes your contract. So, they merely says if the notice period is not mentioned in the agreement, then the notice period will be 15 days. But it does not say whatever written there, which I was saying that I don't like your face, so go out. No, that cannot be done. Once there is an agreement, that cannot be done. Then the notice period, if not mentioned by the parties, statute fix the notice period. But the agreement also, the terms, month by month terms, that remains. The month by month term is remaining there. Parties have agreed to it. And here his notice is premised on only fact that that agreement goes. So, Lordship, we have to test really by operation of law, the agreement goes or agreement is month by month will be associated with 106. So, if it is associated, the terms become associated with 106, month by month to be followed by everyone. Then, Lordship, the termination is not at anyone's will. Now, Lordship, again I will take your Lordship back to the agreement. This agreement was done kindly come to the very first page of the agreement. Whereas the tenant is in occupation of a portion of a second floor of such and such containing a floor. So that means before I entered into this agreement, I was in possession of that agreement. Had it been, he says that I don't know the future, what law will come, I don't know. So if my rights are taken away, I would have not entered. No one can take advantage on. Now, Lordship, kindly turn to they are later dated. Page, no, Lordship, I will be, for the time being, will skip. Not the urgent repair. Kindly come to page 35. 35 and 36. Lordship has got it. Lordship, these are in 2009, 10, 11. So, Lordship, what I am saying is, I tendered the rent. Please find here with a check of rupees this for amount of this such and such drawn on such and such, blank being the rent for the May 2000 as per the court order such and such, detail are given. Lordship has got it. So Lordship, when he filed the suit, in terms of the court order also, I kept on tendering this. Why I am showing this is, if your Lordship looks into that, then Lordship will see that the question of mean profit, because I am occupying someone's place, is not there. Second, I have already deposited with the bank and he is earning bank interest on that. That also is there. So once degree is not there, money is with you, I tendered as per the court order. Can the court hold me for inquiry into mean profit? Now, Lordship, I will take your Lordship to cross-examination of PW1. দিলি আমাকে এইমাত্র দিলি আমি দেখলাম কোথায় না তুই আমায় দিয়েছিস My lord, may I take your Lordship to PW1? Lordship, Chief, I am not doing this. The agreement was PW1 is the vice president of the plaintiff. Krishna Kumar Bihani. Lordship, kindly come to question number 32 of the Chief. Sorry, 28 and 32. May I also show 25 and onward? 25 and onward. I am showing you letter dated 27 May 2022. What is this document? This is a letter dated 27 May 2022 written by me on behalf of the plaintiff company addressed to defendant. In this letter, we have written to them that you are to comply with your letter dated 1st April 2022 for handing over the vacant possession and peaceful possession of the suit premises this. However, in this case, you failed to do so and we will held responsible payment for compensation. Please, sir, I pause here for a moment. Exactly the case which I wanted to demonstrate before your Lordship. That once there is no decree, he is entitled to a compensation. That's what he wrote. This is in chief, not in cross. He first asked me to vacate. Then after a long time, I said I am going to vacate. Then I also did not vacate. So then he wrote to me. He knows what I am arguing today. So exactly what I argued, it is there in the chief, not even in the cross. That they know that if I am making a delay, they will take a compensation from me, and that exactly their letter is. So their further cause of action is this. Lordship, he will try to show that you vacated in this. You have paid me the rent of this. So compensation is this because you have not maintained it. You have not paid this. I could have gone other parties and could get this. But Lordship, the second part, that is the mean profit, how it could fetch. So that much wider than the mean profit. So he could have, he said that is a much wider, and my way of defense is also much wider. But when it is a mean profit, why the mean profit ambit, I will argue further on this, why the mean profit ambit is very narrow? Because you already suffered a degree. You could not defend yourself. So since you have suffered a degree, now it is absolutely clear, and suffered the degree must have gone whatever you wanted to take, division, bench, apex court, wherever. So you could not support yourself. So now it is, someone will see what rent he could fetch and what you are giving, difference you have to pay. So that is once you have suffered a degree. But when compensation is the thing, he will come up with a compensation. I will say that, see, I had to leave your place. So the damage has to be proved. Compensation is unquantified damage he has to prove. And for the purpose of mean profit, he has to only ascertain what could be the rent. So Lordship, that's why he said he has given me a letter for compensation for delay handed. That's his chief. Next. Who has signed the document? I signed me, and it was received by the National Company of such and such. Document is tendered and marked. I am showing you another document dated Exhibit D. Lordship, it is E. Yes, Lordship. Exhibit E ko tare. Lordship, Exhibit E they have given in their evidence, page 27. Yes. Exhibit E, my letter. My letter is D, Lordship.
My lord, is the supplementary judge's brief. My lord, Exhibit E is at page 3.
That is their letter addressed to my client.
My lord, it is also a part of the supplementary judge's brief, page 3.
Originally, the Ramaj. Originally, Joshua lecture. And the document also said compensation. Section 91 of the Evidence Act. Once he said, yes. Yes. Yes, this is tendered and exhibit. True, because section 91 of Evidence Act. I bowed down before your Lordship. So, Lordship, in that case, he said you will be held responsible compensation and damages as well as legal consequence. As well as. So, damage and compensation is the primarily, and then as well as the legal consequence. And in the chief, he said, he stand by that his letter. He said it is damage and compensation. He said only compensation. Now, Lordship, next document. It is signed by me. Lordship, kindly come to Next question. I am showing you another document. 26 to 2000. What is this document? This letter written by the defendant company. They have intimated by this letter that they kindly take possession of the premises such and such hours. What is the date of taking over the possession? 29 September. So, Lordship, they said that I will take a consequence, legal penal consequence, compensation, damage, and then they admit that they have received. I am showing a photograph of order dated such and such, passed by the Hon'ble, tell my lord, what is this? This is an order of the High Court in GA such and such between the plaintiff company and this. Date of the order is 13th April 2009. The document is shows for mark identification. Lordship, that's document which the initial degree and the appeal degree which I said. Now I am showing you two documents, 8th May 2000 this and 20th May 2000. Tell my lord which is it. These documents are written by such and such, regarding the payment of the rent for the month of May 2009 in respect of the premises. First letter dated forwarded the check for the payment of this to the plaintiff company. Another written by plaintiff company following with the month of September 2000. Did you receive this check? Yes. Where is they received by you in a usual course of business? Yes. Did you encash the check? Yes. So, Lord, termination is August 2008. So, after August 2008, there was rent tendered, he accepted. Now 36. Now what prayer he is making before the court? Now he is saying, what is your prayer before the court? He says, mean profit. We have already got possession of the premises. So at this juncture, whether only this prayer standalone can be entertained by the court or not. When he accepted that I received it, I encashed the check after after termination, I received rent. Now, Lordship, we will take your Lordship to the cross-examination. Lordship, kindly come to can you apprise who was the owner of this? The plaintiff company is the owner of the major portion of 6 land. Lordship, 39, 40, 39, 40. The plaintiff company is the major owner of the major portion. Can you explain how do you mean by the major portion? The front portion of the premises we have sold and the major portion is still remaining by the plaintiff on the ownership base. Plaintiff has become the owner of this premises. This company was registered in 9 and the premises is 100 years old. Next, Lordship, then he did not give me the exact date. I am not challenging. I am not challenging. What I am challenging is why this I had to bring. Why? Because this agreement was a special agreement because Royal Insurance Building and Turner Morrison both were the British company. They had a cross-holding, which I tried to bring in the cross-examination, is they had a cross-holding. So that was a special arrangement made. And based on that, it is an agreement where already I was in possession. Lordship, I have shown that they were already in possession. So already I was in possession. So then we have made this. Now he cannot take advantage of 1997 Act. That's what my argument, I'm trying to proceed towards that. So Lordship, yes. I tried to defend my agreement there because that is the only That is the case in the written agreement also, but maybe not that elaborate. There they said that agreement will stand. I am saying that agreement will stand and it has to be in argument. I am saying that that has to be read along with 106. Yes, Lordship. Lordship is skipping it. Ninth July. Yes, I'm deep. 11টা সময় একদম সব I'm deep. Lordship.
ভয় পেয়ে গেছিল।
We had completed our submissions on the last occasion. They were to start.
I'm waiting. Your Lordship will remember, I had made my submissions and finished in August 2024. I started sometime in June. I took 3 days because they did not want to press their application in the earlier suit. So, we are approaching the anniversary. Hopefully, we will finish by the anniversary. Now, I think, we've traveled a long way from where we've started. So, so your Lordship is not troubled too much, for the time being. Please keep your hands off papers, if I may put it not that undiplomatically. And let me just summarize it in 5 minutes. So, we can get to the meat of the issue. Because by now your Lordship's notes will be big enough to probably write a book. I'll just put it in a nutshell, just to simplify it for the time being, and then take your Lordship into the detail. Now, there are 2 suits here. CS number 16 filed by them, which is the earlier suit. CS number 21 filed by us, later suit. Both have the same subject matter, South Point. Both have admitted there is a stalemate. Going by the admitted case, some orders, protective orders, have to be passed. Now, by bringing their suit, they've come in the way of doing it, but the background of it was simply this. And there was a gentleman called Mr. Damani. It was found that he had defalcated funds to the extent of 30 crores. A police complaint was lodged. Investigations went on for a year, and then the police went and arrested. In this background, the emergent board meeting was held by us. Their suit challenges this not board meeting, rather board of trustees and governing council meetings. So these meetings, hey, listen here, will you guys now these meetings are challenged by them on principally 2 grounds. I'll come to that in a second. Now at these meetings, what happens is the money is kept out of all affairs to do with the school, removed. 3 eminent people are appointed as trustees, and then by a meeting of the managing committee, they are co-opted into the managing committee. So this is our set of meetings. Now, they have notice of our set of meetings. Notice is given, admittedly. They say, look, one of them was in police custody, so he could not have. But issue of notice is not disputed, simply that he could not have attended. Now, they have notice of our meetings. They have notice of the resolutions passed at those meetings. Thereafter, we file 144 proceedings. They have knowledge of the orders. Despite knowledge of all of this, they go and hold a rival set of meetings. Now, in that rival set of meeting, again, admitted position is they do not give notice to the persons who are, number one, appointed trustees at our set of meetings. Number two, they also do not give notice to Harshvardhan Lodha, let's call him HUL. So their meetings are admittedly without notice to the members who are there. Now, please read this in the background of one of the principal arguments of Mr. Mukherjee, that look, till a resolution is set aside by a court of law, it stands. Now, what is sauce for the goose must be sauce for the gander. If 3 people have been appointed by me, till you have it removed, you at least have to give him notice. He can't have it both ways. And I'll show your lordship all his arguments cut both ways. So, my lord, despite notice of in his plaint, he says, I have held those meetings. These people were appointed trustees, but I gave him no notice. So, therefore, my lord, suit challenges our meeting. He holds those meetings without reference to us. The object of those meetings is to say, Mr. Damani is a good man. He's being made a scapegoat, etc. So we have challenged it by filing our suit. Now, this is the long and short of the matter. So, at the end of the day, if your lordship looks at it, the crux of the matter is, if, for example, our earlier meeting is held and it is bad, they will not, let us say, put it this way, their rights will improve, but it still won't succeed, but their rights improve. Now, if my contention is right, that our meetings were validly held, that's the end of the matter. His second set of meetings go. So the crux of it ultimately turns out to be, was my meeting validly held? Now, the 2 main objections they have to the holding of our meetings, my lord, is number 1, Harshvardhan Lodha was one of the persons who attended. Mr. Matilal was a second person who attended. Now, they say both of these people could not have attended. That's the argument made. Why? Number 1, Harshvardhan Lodha, he had ceased to be a part of the Board of Trustees because of an order passed by the High Court, or 2 orders passed by the High Court. That is what the resolution says. So, 1, Mr. Lodha had ceased to be a member, ceased, not removed, ceased to be a member by virtue of court orders. And number 2, Mr. Motilal had not attended board meetings and had ceased to be a member. So, 2 gone. If 2 gone, then meeting gone. My meeting is bad. This is the long and short of the argument. So, let me bust it straight away, without getting into too much detail. Now, please first have a look at the plaint. CS 16. My learned friend has argued vehemently. He spent a lot of time showing this document, that document, and the other. Now, please see the pleading in his plaint. No. First, I am not busting Mr. Matilal's ceasing to be a member, because it will take me 30 seconds. Please come to page 6 of the petition. The plaint is, please take the petition only, GA1 in CS 16. Please turn to page 6.
Yes.
Para 9. If I may read, the present, please marks the word, valid composition of trustees and governing council is as follows.
Correct.
Please turn to A. Trustees, item number 6. Mr. Bishwajit Matilal. Okay. So, this entire argument done is completely contrary to his pleadings. He says both these people could not have been there at the meeting. Why? Because Mr. Matilal did not attend so many meetings, he ceased to be a member. He is pleading trustee, item number 5, and governing council, item number 7.
Yes.
So, this is his plaint. This is the case run by him. Matilal was and is a valid trustee and governing council member.
Yes.
So, my lord, out of the people who are there at the meeting, one, my lord, valid. Entire argument made was he is not a member. Goes. Now, my lord, why was this argument made, although it's contrary to the pleadings? I tell your lordship why. Lord, if Mr. Harshvardhan Lodha went, Lord, even then they would not have succeeded. Let's say his appointment is bad. They need to knock out two people. And that pleading is missing in the plaint. They needed to knock out two. They have to knock out Harshvardhan Lodha and they have to knock out Mr. Motilal. They realize this mistake and therefore this argument from the bar.
Yes.
Half a session.
But half a day, half a session went in arguing that not seriously that Mr. Motilal is not a member of the Board of Trustees and the Governing Council.
Yes.
So, my lord, they no reference to their own pleadings, your lordship. Ask them specifically, is it there in the pleadings that he has ceased to be? So, my lord, out of two people who they say were not authorized to attend the meeting or hold the meeting, one gone. So, my lord, half the battle is over for me.
Yes.
Which leaves me to deal with the question of my lord Harshvardhan Lodha. Now, on that, my lord, I had made submissions. Just to keep it short, my lord, at that point of time, I showed your lordship the order given the para numbers. Now, my lord, so many arguments have been made. Basically, the argument made is not threefold. But my argument was, number one, there is no order of removal by either Justice Munshi or by any other court. Number two, if there was a personal disqualification on Mr. Low, there was no order against the society at all. At all. Justice Munshi has said it in not a dozen places in the order, no order can be passed against the society. If at all there was any Lord bar, I'll show your lordship these, so don't bother about it now. I'm just giving it to your lordship in a nutshell. So, my lord, he has said in a dozen places, no order can be passed against the society. Yet, at one place, my lord, he goes on to say, my lord, pass an order which would indirectly affect the societies by saying that they will now be governed in their voting by the decisions of the APL. Only in voting, nothing else. Voting when it came to companies where these trusts had shares, nothing more. Now, but that order was in vogue for about 12 days, 12 days. Thereafter, it was modified by Justice Radhakrishnan's order, which made it clear that this personal disqualification, if any, only related to companies by saying relating to the shares held by the state. I'll show your lordship that, your lordship remembers it. So, my lord, this personal disqualification, if at all went, I showed your lordship the judgments, my lord, which say that if an order is clarified, as Justice Radhakrishnan's was, if an order is clarified, it is not as if it erases the original order, dates back, starts from that date. So, my lord, once the clarification came, then from it takes effect from the date of Justice Munshi's order itself. So, my lord, no disqualification remained vis-a-vis the societies. Trust societies, no disqualification. Number one. Number two, there was no removal during that period. Now, after Justice Munshi's order and Justice Radhakrishnan's order, after that, after these clarifications have come, which make it clear that the trustees and societies are not affected in any way, it is after that that the APL writes a letter. I'm just giving your lordship the chronology. I'll show your lordship these. Supposedly writes two letters to these societies. Those letters are not on record. They don't disclose it. Apparently enclosing some opinions that they have obtained. The letter is commanding the societies saying that HVL has ceased to be a trustee pursuant to orders of Justice Munshi and Justice Radhakrishnan.
Yes.
And my lord, the resolution simply records that. So, my lord, my argument was there is no independent resolution of removal. He has not been removed. The resolution only, my lord, says, it says records adopts notes and notes. Records, notes and confirms. So, my lord, there is no independent, my lord, order of removal. Now, my lord, faced with these, and then, my lord, of course, the third chapter came. My lord, ultimately, on a final hearing, all of this was set aside, became as if it's not there. Now, faced with this problem, my lord, what did they argue? To circumvent it, the argument is, look, Justice Munshi's order may have been wrong, but it's not an error without jurisdiction. It's an error within jurisdiction. Therefore, APL had the full right to do all of this. This is the argument made. Now, the division bench has said they had no right to go 1 inch more, or 1 centimeter more than what the probate court itself could have done. And the probate court could not have done this. So, my lord, they accept that that portion of the order may have been wrong. But the order is, as originally passed, was not a nullity. And therefore, the resolutions are good. Now, these two don't link together. Because in the first place, there was no order of the court removing him. And there is no independent, my lord, resolution by the society removing him. So, my lord, the resolution on which they rely on to say that this is an order of resolution, I'll show that to your lordship. Now, either your lordship will say the effect of that resolution is that he stands removed or he does not. But the important thing to note here, my lord, is that the two letters of the APL referred to in those minutes or in that, my lord, resolution says that he has ceased to be a member pursuant to orders of the High Court. That's clearly wrong and a misrepresentation of the, my lord, orders. That I'll show your lordship. Now, if that is clear, my lord, it doesn't matter whether the order was within jurisdiction, without jurisdiction, resolution not there, finished. But, my lord, I'll take it a step further. I'll say, my lord, I'll put it this way, that, my lord, the orders were a nullity because, my lord, it was beyond the subject matter or jurisdiction of the probate court, and that is recorded both by Justice Munshi and by the division bench order. Because the probate court does not have, my lord, any jurisdiction, number one, to decide any questions of title, and number two, to pass an order against third parties. This is how I'll put it. But this is not a case of lack of territorial jurisdiction. It's not a case of lack of pecuniary jurisdiction. It is a lack of subject matter jurisdiction, and I have placed the judgments, my lord. Your lordship will remember, 1969 Supreme Court, not official trustee. But I've showed that to show that, look, if it's subject matter jurisdiction, it is a nullity and no independent proceeding needs to be filed. Yeah. No independent proceeding needs to be filed. It's a nullity. So, my lord, this also will take care of their argument that I had to file a separate proceeding challenging that resolution. Because Mr. Mukherjee's argument is, look, you did not file a proceeding to challenge that resolution. Now, my lord, see how it cuts both ways. In my case, resolution there, he ignores it and, my lord, holds another meeting without giving notice. But in his case, my lord, it's fine. In my case, it stands and I have to file a suit. It can't be, my lord, it can't work in his favor both ways. So, my lord, this is, my lord, the crux of it. Now, my lord, let me take your lordship a little deeper and, my lord, show your lordship these orders. My lord, before I take your lordship to the orders, I think, my lord, it's important that I show your lordship the resolution. Because, my lord, like I said, that is the crux of it. Please take page 42, 43.
43
of CS 21, my lord, my suit.
A1, CS 20.
A1, I'm sorry, yes. Anything I want to say with regard to all this thing? Where's my folder?
Yes.
Well, I'll trouble your lordship with it because everything turns on it, really speaking. Now, your lordship can mark the date of 16th April 2021 on this. This is the notice. But the date is on at page 45. Your lordship will get it at the bottom of page 45, 16th April.
Yes.
The resolution, according to them, was dated 21st, 22nd. Now, I won't read not all of it, but not if your lordship comes to the third para. Just to show your lordship, not the background. after the demise of third para at page 43. After the demise of Srimati Priyamvada Devi Birla, various disputes arose in connection with the succession and extent of estate of late Priyamvada Devi Birla, and the same are still pending before the probate court at Calcutta. Late R.S. Lodha, who had propounded a will of Srimati Priyamvada Devi Lodha, bequeathing her entire assets to him, was already a trustee and vice president of the governing council of the society at the time of her death, and became the president soon after her death. His son, Harsh Lodha, became a trustee and governing council member of the society, but please mark the date, September 2003. So he's been there from then. Sri R.S. Lodha passed away in 2008, and after him, Sri Harsh Lodha, who was an intestate successor of R.S. Lodha, is also one of the claimants of the estate, later became the president of this society. So admitted that he was the president. Now, not by a set of judgments and orders, not it goes on to not how the APL was appointed. Not I'm not bothering your lordship. Then, Lord, please comes to page 44, top of the page. Oh, I'm sorry, Lord. Please go back to page 43. I'm sorry. I'm very sorry, Lord. The last para on 2nd November. On 2nd November 2020, the society received a communication from Khaitan and Company enclosing the following decisions, judgments, orders. Copies attached. Please mark item number 3 and 4. Judgment and order of 18th September 2020. This is Justice Munshi's order, and order dated 1st October of the Honorable Division Bench. So these two orders are being forwarded. Now, the letter dated 12th November 2020 received by the society from the APL committee, copy attached. Now, that copy is not attached by them, not anywhere, not available, contains judgment and order dated 18 September 2020 of the learned single judge and the order of 1st October of the Honorable Division Bench at Calcutta passed in the matter of probate proceeding, etc. Then, not a second letter is written. The letter dated 27th February received by the society from the APL committee informed that the APL committee at its meeting held on 26th February, so not the APL committee has decided, not the trust. APL committee at the meeting held on 26th February 2021 has decided by majority. Now please mark it. Who has decided? APL has decided. Correct. By majority to nominate the following persons for being appointed as trustee, member of the governing council of the society for a period of 3 years from the date of appointment, and shared their profile. Then let's skip the names. The APL committee in the above letter of 27 February has also stated that the existing trustees, governing council, managing members of the society do not include. So who is deciding it? APL is deciding. Do not include Sri Harsh Vardhan Lodha anymore on account of the judgment dated 18 September read with the order of 1st September. Yes. So APL has decided that the High Court has decided this. Now, then, Lord?
Yes.
Yes, Lord.
Yes. Yes, continue.
Yes. Then, Lord, two societies, namely MP Birla Netralaya and MP Birla Research Center, both part of MP Birla Group with similar facts in case, have in the meantime obtained opinion in this matter from Justice so-and-so on the following. And Lord, please see item number 1, whether Harshvardhan Lodha ceases to hold office of trustee and chairman and member of managing committee in these societies. So, Lord, the words used, operative was ceases to hold office, consequent to the joint reading of these two orders.
Yes.
Now, Lord, these are the two questions. Then, Lord, the opinion of Justice so-and-so on the above two queries is in the affirmative, or copy of the opinion is enclosed. Not given here. Copy of the memorandum of association and rules are also enclosed. In view of the above, now, Lord, please see this. In view of the above, your consent is hereby sought on the following resolutions, which are intended to be passed by circulation. Resolved that the cessation of Sri Lodha as trustee and member of the governing council of the society, consequent to the judgment dated 18 September of the single bench and the order dated 1st October of the division bench, passed in the matter of probate proceedings in respect of estate of so-and-so, as communicated, now mark this, this is the operative, as communicated by the joint administrators pendent lite of the estate of so-and-so by the letters of so-and-so, be and is hereby noted, confirmed and taken on record. So what's being taken on record? The decision of the APL, nothing more. Nothing more. What is being noted, confirmed and taken on record? Milord, please see this.
Resolve the cessation of so-and-so of the so-and-so 18 September.
As communicated by the office. Cessation as communicated by the office of the joint administrators by their letters is taken on record. So, to put it very badly, it is the letters which are being taken on record. A communication in the letter they have said, yes, ceased. We are taking that on record. That's all that there is.
That is the resolution.
There is no resolution saying that he is removed. We are removing him. We remove him pursuant to the resolution. Please don't, you said it. Don't bolo na. There is no, please see the next two resolutions. Further, that as requested by APL in terms of so-and-so, they appoint someone and then they appoint one more. But there is no resolution saying he is hereby removed. So, if the High Court order goes, this resolution goes, it is only recording that the APL says that the High Court has removed him. Firstly, there is no order of High Court removing him. Number two, the APL is clearly misinterpreting the order or misrepresenting it. Number three, the High Court orders went. Yes. So, if all that goes, is there any resolution which says he stands removed? None.
What about the confirmed and taken on record?
Yes, so what is being confirmed? That the APL says that the High Court says that he has been seized. He has seized.
Yes. Because the
Yes.
first paragraph, the APL committee in the above letter stated that the existing trustee governing council meeting, including Harshvardhan Lodha and even prior
Yes.
to that.
APL letter says that the High Court says that he has seized.
Correct. And that they have confirmed in the meeting.
Yes, they are saying very well. We are confirming that we have received a letter from the APL saying this.
Yes.
Nothing more. There is no removal. But after all, please remember, this is a letter which has come from the lawyers. The APL is not now being advised by lawyers. Not everyone knows how to remove someone. It is resolved that Mr. XYZ is removed. One doesn't find that. But look at the rigmarole over here, my lord.
Because they have asked for the opinion from the retired judge.
Correct.
Honorable retired judge. And
Yes.
retired judge has given the opinion in affirmative.
Yes.
Affirmative. Copy of the opinion was enclosed with the memorandum of association.
Correct.
And that was communicated to the society, and the society has taken on record and made it confirmed.
Correct. So, my lord, let me put it this way. My lord, your lordship will find from one of the paras here that two societies, not this society, sought a opinion. That opinion was given to the joint APL. Two of the three APLs then decided to forward it, saying that, look, the opinion says, or we are of the opinion that the High Court says that he has ceased to be. Now, let's not even go this far. Let us say, the High Court did not say he has not been removed. Let's say that, let's for a second assume there is no order of the High Court saying that he stands removed. But this letter says, look, we have received the opinion, he has been removed. I am forwarding it to you for your necessary action to remove him. Now, that is also not the situation, because here your lordship will find it is in the nature of a command.
Yes.
So the decision is that of APL. There is no decision of the society or the trustees. There is no, my lord. independent resolution. And these are the three resolutions of which confirmation was sought. There's nothing to show it was confirmed otherwise, but I'm not going into that. But my point is there is no independent resolution for his removal sought.
Correct. Okay.
Apart from this, that there was no order of the High Court saying remove. Please see the language again. The letter dated, right at the top, letter dated 12 November received from the society contains a judgment, an order, not annexed, and then, my lord, after these annexures, your lordship will find that they say resolved that cessation of Mr. Lodha as trustee, president, member, consequent to the judgment. But it is made not linked to the judgment. It's not inherently linked to the judgment. It is not said to be independent. So if there was no judgment saying this,
The opinion, judgment and the opinion.
no, Lord, this part is not linked to the opinion. The resolution is not.
Achha, first one, yes.
The resolution is not linked to the opinion. It is linked directly to, it says, look, the High Court says he has seized.
Yes.
Now, if the High Court did not say it was seized, not what would be the effect?
Okay.
Consequent to the judgment, it is linked, not inherently linked to the two judgments. But I would have understood it was only linked to Justice Munshi's judgment.
Yes.
But it is linked to both.
Yes.
So, my lord, if I may again shorten it, resolved that the cessation of Sri Lodha, consequent to the judgment of the High Court, as communicated by the office of the joint administrator by these two letters. So, that is all that is being done here. So, my lord, number one, I had argued no independent resolution. Number two, now I intend to show your lordship, there was no order of the kind that they are talking about. Cessation.
Yes.
So now, my lord, may I straight away take your lordship to the two orders in question. Lord Justice Munshi's order, longish orders, I'll show your lordship a few paras because it's necessary now, my lord, at this stage. Now, my lord, if your lordship would take GFO in CS 16, because they had not annexed all this. We annexed it to our order 7 rule 11. কপিটা আমারটা বার করি আমার আইপ্যাডটা কোথায় Volume 1. We'll need both volumes actually. Not we will need all the volumes. Yeah, because all the judgments are not annexed there. Now, my lord, if I could start your lordship off from. No, action. No. Lord, this starts at page 40.
Yes.
Justice Munshi's order.
Yes.
And, my lord, may I request your lordship to take the internal page of the, my lord, judgment. It will be a little bit more convenient for me because, my lord, otherwise I would have had to mark it in 5 different places. I have a marked copy. So please excuse my laziness.
Yes. Internal page?
My lord, internal page 50. Now, here, my lord, I'll just give your lordship a little background. There's 50 pages before this. The background is this, my lord, that APL passed certain decisions. But one group of people asked for implementation of those resolutions and acting as if not these companies, which were not a party to these proceedings, a large number of companies, they hold shares in each other, cross holdings. So they act like these are part of the estate. Even though held in the names of companies, they are part of the estate. So based on that, they asked for not orders with regard to the annual general meetings of these companies. Now, companies are not parties. An order is passed. So the companies go up in appeal and the court says, look, no order could have been passed without giving notice, sets it aside and says, look, you hear it. After hearing, these parties. Now, important thing to note here, only one important thing to note here, some companies were given notice. Societies and trusts were never given notice. They were never given notice, so obviously they felt that, look, we can't interfere there. It's in this background that the matter is being heard. Now, Millard, please come to. So the companies argued that, look, Lord, before this finding, Lord, two more sentences. So the companies argued, look, probate court can't decide title. It can't decide things against and pass orders against third parties. It's completely foreign to the jurisdiction of the probate court, testamentary court, and therefore you can't. This was the principal argument. There were a number of subsidiary arguments, and Lord, we had, let's put it this way, Lord, experts and Lord, really good counsel from Bombay and other places addressing the court at that point of time, which was a pleasure because Lord, it was COVID days, so it was online court, and Lord, we got to hear some legends of company law also. Now, Lord, at page 50, if your Lordship sees, inner page 50, if I may read from there.
Yes.
Since I have held that the companies being not parties here, they are not amenable to the jurisdiction of the probate court. Therefore, prayer for interim injunction against companies who are appellants before the division bench and not parties to the proceedings is refused. So Justice Munshi holds clearly not amenable to the jurisdiction of the probate court. Now, Lord, please permit me to make two comments, sir.
Yes.
Lord, was the court talking about pecuniary jurisdiction? Was the court talking about, Lord, territorial jurisdiction? Or was it talking about subject matter jurisdiction? There is no third kind. It's either pecuniary, territorial, or subject matter. So when the court says that it did not have jurisdiction, it says, look, probate court can't pass these orders. So it's subject matter jurisdiction. Then, Lord, from here, if your Lordship would come straight to inner page 98. Well, a lot of judgments are cited, the arguments are there, and in a dozen places, Lord, he holds that no order can be passed against, not in these proceedings, in 12 places. And that's recorded by the division bench.
Yes.
Now, my lord, from here, if your Lordship comes to page 98,
Inner page 98.
my lord,
Inner page 98.
inner page. Not all pages which I give your Lordship. Not again, page 98, first not para beginning there, accepting what has been submitted by Mr. So-and-so, that the noticee company Birla Cable, being not a party to the probate proceeding, court cannot pass any order of injunction which has been filed, etc. So, Lord, this is another place. And then, Lord, again, if your Lordship turns the page, Lord, goes to the bottom of the page, the last few sentences. Lord, 6 lines from the bottom of the page, therefore, further elaboration on submission not necessary. Where he made the submission on merit, whether, etc., Lord, is not a matter to be gone into in detail. Therefore, GA 834 stands disposed of to the effect that the probate court cannot decide any issue against a stranger to the probate proceeding. And no order on this probate proceeding can be passed against the noticee company. So, court says, I will not get into merits. There is no jurisdiction. Then, Lord, please see the next paragraph. GA number so-and-so has been filed by Birla Cable, seeking for necessary correction in the order by recording its submission as indicated in para 5. Since this court has already observed that no order can be passed against the stranger company, this application become infructuous. So this kind of finding is there in a dozen places. And if your Lordship then comes to 101.
Yes.
He submitted that the jurisdiction of the probate court is very limited to the extent it can only examine genuineness of the will and other consequential issues like testamentary capacity of the testatrix to make the will, due attestation of the will, and whether the same is the last will. That's the limited jurisdiction of the probate court. There is no controversy to the proposition relied on by Mr. Chinai that this court cannot extend its jurisdiction to his client who is not a party to the probate proceeding. Since this court lacks jurisdiction over an entity which is not a party to the proceeding, the court does not feel it prudent to deal with other issues, particularly intricacy of all the provisions of the Companies Act. So, Lord, lacking jurisdiction being decided with regard to every company which has applied. not accepted, and this is not pecuniary jurisdiction, this is not territorial jurisdiction, it is subject matter jurisdiction. Then, Lord, please comes to 107.
Yes.
Now, Lord, Mr. Chinoy again, Lord, he's arguing another point. Now, please see the last pair on that page. There is no dispute about the proposition. However, in my view, these decisions can't address the issue involved in the present case, since I've already held that this probate court has limited scope to exercise jurisdiction in respect to entities not party to the proceeding. Flouting or non-flouting by appeal of the provision of the Companies Act is not an issue to be decided by this court. Parties will be at liberty to raise the issues before the appropriate forum for redressal. But therefore, Lord, these can't be. Probate court can't do it. I'm not getting into the law. I'm not getting into company law issues. I'm not getting into merits.
The next volume.
No. Yes.
Next
Then Lord, please take the next volume. But page 112. Internal page, I'm sorry.
Export of company law. And what's your
Yes.
Now, Lord, page 112. Lord, third para. There is no difficulty for this court to accept this proposition as submitted by Mr. Bandopadhyay. Probate court cannot extend its jurisdiction over a person or entity who is not a party to the proceeding. I'm just showing your lordship that in a dozen places it says no jurisdiction. Then, my lord, please see. Lord, 114. Last para. Summing up, the submission that has been made on behalf of three noticee companies by Mr. Chinoy, Mr. Bandopadhyay, Mr. So-and-so, this court is of the firm opinion that so far as they are concerned, no order of restraint of any kind can be passed by this probate court since they are not parties. Now, my lord, societies were also not parties. Trusts were not parties. And my lord, the court says, look, I can't pass any order of any kind. This order is being construed to say not the trusts and the societies were bound. Then, my lord, from here, if your lordship would not come to straight away to page 146.
Yes.
Now, my lord, after holding this in a dozen places, Lord, your lordship can come to, Lord, your lordship could see this portion also, 146 at the bottom, last para. Although in the present case, I have held that the three noticee companies are not amenable to the jurisdiction of the writ court for the present, and no order of restraint as prayed for can be passed against them, but to deal with the submissions made by the noticee companies, etc. So, Lord, he says, I have not discussed company law, etc. But he says it would be, then he gets into, Lord, the company's law aspect. Not from here, then, Lord, if your lordship comes straight to 154.
Yes.
Lord, the third para. Therefore, so far as the three noticee companies are concerned, upon consideration of the submissions made by the learned counsel, so-and-so, 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 court on consideration of the ratio of the judgment and so-and-so, cited by so-and-so, the firm view that for the present, the noticee companies being not parties to the proceeding, no order can be passed against them as paid for by the defendants in the application. Then, my lord, please see 156. This one.
Yes.
Where's the stay observation page one? What are you skipping? But I'm sorry, I've missed out one portion which is important for our case. Very important for our case because that's what they rely on. But please goes back to page 151. This is the para which created the confusion, which not necessitated the appeal before I show your lordship the right. Now, so after saying in a dozen places that no order can be passed, now please see what he says at the bottom of page 151, going into 152, 5 lines from the bottom. This view has been confirmed by both the single bench and division bench, and in view thereof, APL committee is well within its power to ask all entities which were under the control of PDB to exercise their voting right in regard to their investment in the share capital of any of the companies which are under the control of PDB in the manner considered by APL as is beneficial to the interest of the estate. All these entities of the group would have exercised their voting rights in accordance with the directions if she had been alive. Accordingly, now this is the part. Now, such entities would exercise voting rights flowing from the investments in the companies controlled by PDB in the manner to be guided by APL. Now, let me pause here for a moment. So, on the one hand, says that look, no jurisdiction, I am passing no order, then this one stray line. And this has been set aside by the division bench as being in contradiction. Court has clearly held it is inconsistent with his findings in a dozen places. Now, please also see, in any case, it makes no difference. It cannot, affect or give any right to APL to appoint or remove anyone in the society. I'll tell your lordship why. Because the extent is accordingly now such entities. For a moment, let me read entities to mean trust. Now such trusts would exercise voting rights. So limited only to exercise of voting rights in those companies. So, if I am told please exercise voting rights in Birla Corporation by voting in a particular way, that is all. But it's not giving APL the right to remove my person or to appoint anyone new. This is the limited extent. That's all. Accordingly, now such entities would exercise voting rights flowing from the investment in the companies controlled by PDB in the manner to be guided by APL. So that is all. APL can ask my trustees to vote in a particular manner when it comes to holding of AGMs in those companies. Nothing more. Now, this is stretched by the APL to say they can remove people, appoint people, and all of that. Now, after all this, the directions which are passed, the operative portion. Now, please comes to. So, after saying now these entities will exercise voting rights, now, please come to 154.
Yes.
Third line. Even after he said this, now see what he says. Therefore, so far as the 3 notice companies are concerned, on consideration of the submission made by the Learned Counsel, this court, upon consideration of the ratio and so, is of the firm view that the present notice companies, not being parties, no order can be passed. So he keeps saying all through, no order can be passed, and yet he says APL will guide them when it comes to voting. APL stretches that 1 mile further. It's given half an inch. It takes it 1 mile further to say, look, I can do what I want in these societies. Now, please see the operative portion. In the operative portion also, no order against the societies. If I may read, at page 155, your lordship will just see, quote, last 3 lines before ABC, this court in aid of final relief in the testamentary conferred under so-and-so act passes the following orders. So, orders being passed, please see. No order against me. Plaintiff shall implement the decision dated 19 July. Taken by the majority, as all consequential decision of the APL and furtherance of such decision shall be restrained from drawing any benefit personally out of the asset. So, no personal benefit. Then B. Plaintiffs are restrained from interfering with the decision of APL and any decision which might be taken in future by the majority if the same directly or indirectly relates to the estate of the deceased, and further the plaintiff is restrained from holding any office in any of the entities. So, personal restraint on Harsh Lodha, no order against the society.
Yes.
Personal.
Yes.
Defendants restrained from an injunction from interfering with APL decision. And then, my lord, if your lordship goes to the bottom of 156, Item number 4, GFO, in view of the discussion made at so-and-so, this applicant stands disposed of to the effect that this probate court cannot decide any issue against a stranger in the probate proceeding, and no order can be passed. So, my lord, that sting in the tail, one, my lord, stay observation remained. Now,
the benefit of the advocates.
Lord,
Benefit of the advocates.
Lord, your lordship does not know how much benefit. But I'll tell your lordship, since your lordship, those were COVID days. So court was shut for 3-4 months. Then Lord, online court started. So where most of us expected that our income will fall by 95%, well, at least Lord, our income rose to 30%, largely because of this, Lord. And it kept us occupied the whole day. Lord, online hearing, Lord, credit to Justice Munshi, he would hear it, Lord, from morning till daily basis, every day. So, and Lord, of course, benefited a lot of counsel from Bombay also and Delhi also. So, yes. So now, Milord, number one, Milord, the 4 conclusions which I draw here. He is very clear, no order can be passed against third parties. It's beyond his jurisdiction. So, subject matter jurisdiction not there. Number 2, Lord, there is no order against the society, very clear. Disqualification, if any, on HVL is a personal disqualification.
Not the society.
And that, Lord, went in 12 days. Now, Lord, in this context, please take, Lord, page 199.
No, stop here.
Oh, yes.
One sentence, so I'll just do it.
But could I just, yes, not finish off just that part. Lord, please take 199. The operative portion, the page.
199.
At 212. Just that. I won't bother your lordship with the rest.
212 running page.
212?
No,
the judgment.
The main page. Because we are now on the division bench.
Yes.
Not ad interim judgment. Justice Radhakrishnan's.
Yes.
Para 20.
Para 20.
We may, however, clarify, Lord, please mark the word clarify, that the word implement occurring in para A among the 3 directions issued by the judge means abide by. Now, this next portion is important. It is further clarified that the operation of para B of the directions would be a restriction on the plaintiff Harshvardhan Lodha to the extent of it being a restriction from holding any office in any of the entities of the MP Birla Group during the pendence of the suit on the strength of the shares referable to the estate of PDB. So, in other words, if you are elected pursuant to a shareholding, then it's a disqualification. Otherwise, it's not. Now, Lord, a trust or a society has no shares. His election to this was not on the dint of any share.
Yes.
So, Lord, personal disqualification, if any, went completely in 12 days. Now, please not mark the date of this judgment, but 1st October. It's important in the context of that resolution. Now, that your lordship will find at page, the date your lordship will find at page 199. 1st of October.
Yes.
Now, why is this important? Because by the time the APL, Milord, sends these letters in November and January,
Yes.
the restraint, if any, had gone. Which is why, Milord, I was pains to say that when it says that he has seized by virtue of High Court order, answer is no. It is a complete misrepresentation, which is perhaps why, Milord, these letters have not been disclosed. But it is clear from the resolution itself, if I can just, not once more, take your lordship back to the resolution now, not in light of this, so I don't have to come back to this aspect of the matter. If your lordship goes back to page, resolution, page 43. Lot of CS 21, which I showed your lordship at the beginning. If your lordship now, Lord, looks at the resolution at page 44.
Yes.
Not if your lordship goes to the top of page 44. The letter dated 12th November 2020. So this is coming after 1st October. Contains the judgment, not both Both of them are there. Both these orders are there. And then, my lord, please take the resolution itself in this context.
Yes.
Resolved at the cessation of Harsh Lodha as so-and-so, consequent to the judgment of so-and-so, so-and-so. Now, can it be said consequent to these judgments he has ceased to be a member? On the date when they are sending these letters? And what the division bench at the final hearing says is all wrong, all of it. So, Lord, this is the nutshell part of it. In other words, Lord, they said meeting is bad because of both Mr. Matilal and HVL being disqualified, having ceased to be. I've showed your lordship, plain says he was validly appointed, and HVL, this is the position. There is more, there are 5 other orders in this proceeding itself, which I'll show your lordship.
Thank you.
You fix for an email.
I'm sure he will.
So ये यहाँ से लिख लेना, पूरा पार्टी का नाम है कॉन्सुल फॉर द plaintiff in CS number 21 of 2024 has argued at length, but due to paucity of time, hearing could not be completed. It is found that the matter कल भी है क्या? Could not be argued. Due to paucity of time, matter could not be argued. According case is adjourned. Let the matter appear on कब है? और 21st and 22nd July at 12:30.
12:30. Can it be a little 12 o'clock? A little time, not 45 minutes.
12 o'clock
I leave it here. I know your lordship has.
23, 24? 23, 24 July. 12 कर दो, 12 noon.
Lord, 24th, my junior will not be here, and Lord, he is very able assistant, not in the matter. 23rd, your lordship can
23,
keep it.
25.
24, 26.
Lord, 24, 25th, 26th, he is going to Bombay, Lord.
28, 29.
Your lordship will give it 23rd
12,
and 29th. No, no.
12 noon. हाँ? कब है? Time बोलो. 12 noon. 30, 31, 12 noon.
12 noon.
Oblate.
Wait.
The time for the plaintiff.
Witness.
This matter, the defendant had only filed their written statement, and thereafter they have not been representing themselves. But we have filed a judge's brief of documents, which with the department, I hope this there, yes. Then may I have my lord's leave to file the affidavit and evidence with it?
I
I
solemnly affirm that
solemnly affirm that
in
in whatever
I will depose
I will repose
by way of evidence
by way of evidence
in this suit,
in the suit,
I shall speak the truth
speak the truth,
and no part of it
and no part of it
shall be false,
shall be false,
and I shall not conceal anything.
conceal anything.
What is your name, sir?
Udit Siroya.
You
DIT SIROHIA.
father's name?
Late Sudhir Siroya.
Sudhir.
SIR SIROHIA.
Age
36.
Occupation.
Business.
Residential address.
2 Clyde Row.
2
CLYDE.
PL
YDEROAD. Hastings.
Road. Clyde Road,
Ha-
Hastings, Calcutta.
22 700022.
Yes.
Mr. Siroya, how are you associated with the plaintiff company?
I am one of the directors of the plaintiff company.
What does this plaintiff company do?
We are the plaintiff companies in the supply of agrochemicals to tea states for
Go slowly. Go slowly so it can be recorded.
2 tea states in Bengal and Assam.
Slowly.
Yes.
I'm showing you one document. Kindly have a look at this and let the court know what is this document.
This is the board resolution authorizing me to file proceedings and sign Walatnama and other documents in matter relating to legal proceedings.
Who has issued this? Who has issued this board resolution?
This is issued by the plaintiff company HTC Impex Private Limited.
Do you recognize the signatures put in this document?
Yes.
Who are these signatures of?
One is Udit Siroya and the other is Ronak Chajer. Both are the directors of the company. Ronak Chajer.
Spelling.
RONAK CHHAJER.
How are you aware of the signatures of this Mr. Ronak Jhajar?
He is the director of the company.
Have you been seeing the signatures?
Yeah, it is been done in the usual course of business.
Say yes.
That
Yes.
they attended this as the
Exhibit
exhibit
A.
1. Hey, sorry, Millet.
Exhibit A.
Let her finish the question, then you answer. Slowly.
Slowly re-record it.
Exhibit.
Yes. Next.
Mr. Siroya, how are you related? How are you associated with the defendant company?
The defendant company approached us for supply of pesticides to control infestation of pests.
What is the business of the defendant company?
The business of the defendant companies, they manufacture tea.
What is the business relationship that you have with them and the procedure adopted by you, by the parties in the lists?
We have a business relationship where we have supplied goods to the defendant company. Goods namely insecticide, pesticide, fungicide.
What is the procedure adopted by the parties?
The general procedure that it was adopted was the defendant company used to ask us on mail or on phone through
Yes. Yes.
ask on mail or phone over and send their inquiries of the required chemicals to be supplied. We had quoted them on email or on phone, and once the order was finalized, then the procedure starts. Can I explain?
Please carry on.
Witness volunteers.
Once the order is issued, then I used to give the delivery order from where the respected chemicals need to be collected from Siliguri, and then we used to hand over the mail and give the delivery order through mail. Delivery order through mail.
Keep your speed little slow.
Go slow, Mr. Siroya.
Yes. Yes.
We used to give the delivery order. Delivery order.
Used to give the delivery order through mail. Yes.
From
Next.
where the respected materials need to be collected.
Yes, next.
Once we have sent the mail, the representative of the defendant company, along with the printout of that delivery order, used to come at Siliguri location to collect the materials. Then the driver mostly the driver or the representative of the company used to go to collect the materials and put a signature on the delivery order or invoice. The principal company, on taking signature from the representative of the defendant company, used to provide us the proof that the representative of the garden has collected the materials.
Yes.
On receipt of the same, we used to submit the tax invoice in a bill cover to the defendant company.
Mr. Siroi, I am handing you a bunch of documents which are appearing as PD1 at pages 1 to 49 of the judge's brief of documents. Kindly go through the same and let this court know as to what are these documents all about.
The first document is the delivery order, the purchase order issued by the defendant company to us, dated April 19, 2018. As I had explained earlier, that I used to send the delivery order to the defendant company from where the materials were to be collected. This is an invoice copy where the signature and the truck number has been mentioned by the representative of the defendant company. This is the the red pink document is the manual challan that we used to prepare when the materials were to be collected. The first page is the tax invoice. It indicates a lot of details. The invoice number along with date, the GST registration number of the plaintiff company, the delivery challan number along with date, the garden details, and the destination. Also, the payment terms are mentioned 45 days. The item description of goods, the item name along with manufacturer, HSN code, quantity, HSN code, quantity, unit, rate are mentioned. Further down, our bank details are also mentioned, and it is also mentioned payment must be made within due date, otherwise interest at the rate 21% per annum will be charged extra on overdue payment. And on a overdue payment.
Yes.
No, these are a bunch of documents which are all similar. I'm tendering them as a bunch in itself. Pages 1 to 49, PD1. But may I tender them? Have they been issued in the usual course of business?
Yes.
Who has signed upon the tax invoices?
This has been signed by Mr. Chattar Singh Bed, our accountant, my accountant.
Are you aware of his signature?
Yes.
Has this been issued in the usual course of
Yes.
business? Are these documents true and correct?
Yes.
May I tender them as Exhibit 2? 2 or B, Dada?
B
2
collectively.
B collectively.
B collectively.
B collectively.
Pages you mentioned.
Pages 1 to 49.
1 to 49 of JBD. Yeah? Yes, next.
I'm showing you 2 documents. What are these?
These are the bill covers that we usually maintain with each of the company that we do business with. Further, it indicates the name of the company, serial number indicating the invoice number, the date of invoice, the amount, and the signature. It indicates the signature of the representative of the defendant company along with the date when they have received the invoice.
How are you aware of the details of these mentioned in the bill cover? How are you aware of the details as mentioned in the bill cover which you've just now mentioned?
These are done in the usual course of business. These are the bills that the plaintiff company has raised on the defendant company.
May I tender them as
Exhibit C collected.
Exhibit C. They are at pages 48 and 49 of the JVD, Millet. 48 and 49. 1 to 47 হবে প্রথমটা, sorry.
Yes, next.
No, ভুল করে। তাতে bill cover লেখা আছে। bill cover লেখা আছে। And the bill cover লেখা আছে। হ্যাঁ, at 48, 49 এটা হবে। দাদাকে বলে দিলাম।
Yes, next.
Kindly have a look at this document which has been handed over to you and let the court know as to what is this. This is appearing at PD2, pages 50 to 54 of the judge's brief of document.
This is the ledger maintained by the defendant company with the plaintiff company. It is a debtor's ledger.
Debtor's ledger.
Yes.
On top, the period is mentioned as 1/4/2017 to 31/3/2018.
Yes.
It is indicating, the ledger is indicating the date of the transaction, invoices, amount, and the payment receipts. Lastly, the 7,34,739.80 is the closing balance as on 31/3/2018. The second is the ledger from 2018, 1 April 2018 to 31st March 2019. It is also the same, indicating the same transactions. They used to make on account purchase, sale and payments. And they used to make on account trickling payments. The third is ledger from April 2019 to March 2020. Also indicating the same sale transaction and the payment receipt. Further, they had issued some checks on September 19. September 2019. Some checks were issued, and on regularly calling them, and they refused to deposit as they were facing financial difficulties. So finally, some 7 checks.
Finally, some 7 checks.
7 checks were dishonored, leaving a closing balance of 9,14,115 as on 31st March 2020. This is the last ledger from April 20 to March 21.
In whose books are these ledgers maintained?
Plaintiff company.
Are these ledgers issued by you?
Yes.
Are they in the usual course of business?
Yes.
Are the details in this ledger true and correct?
Yes.
Then may I tender this as Exhibit D collectively?
D.
Mr. Suroi, I'm handing you 7 checks. Can you please have a look and let the court know as to what are these checks all about? They are appearing as PD3, pages 55 to 61 of the judge's brief of document.
These were the 7 checks that were issued by them in usual course of business. The date mentioned being 17 September 2019 for various amounts. On calling them regularly, they had told that they are facing with financial difficulties. So due to 3 months time, it was deposited on 5th December along with the dishonor 6th December along with the 6th December 2019 along with the dishonor memo from our banker.
Are these checks bearing the signature of whose signatures are there on the checks?
The director of the company, namely Mr. Saurav Garg.
Are you aware of his signatures?
Yes,
How are you aware of his signatures?
because they used to issue checks regularly. Usual course of business.
May I tender them collectively as
collective.
I'm handing over to you a bunch of documents. Please have a look at them and let this court know as to what are these documents. They are all appearing at PD4, pages 62 to 119.
As the business was going on a regular basis, we had asked them for release of overdue payments.
Overdue payments.
In the first page also they are saying, dear Udit ji, regret saying this, but we will not be able to do anything right now. Please support us during this time as Darjeeling is most trouble avenue still. Most trouble avenue still.
Travel avenues.
Basically, these documents are the reminders sent from my email to the defending company regarding the release of overdue payments. It indicates the total outstanding at a given point of time.
Yes.
Who has issued these emails?
These email have been issued by me from my personal computer.
And to whom have you issued the emails?
I have issued it to the defendant company and one of the directors.
There are 65 beat in that respect has been already filed with it. The bunch, may I tender the entire bunch of
Exhibit
documents
F
which are
collective.
communications as F.
Exhibit F collective. Next.
One minute, madam.
Mr. Sorry.
In the email dated 21st August 2019, I have specifically asked, it is written in the email, Sauravji, can we meet tomorrow?
It is written in the email. I had specifically asked,
Saurav,
and it is written in the email. अभी बताइए.
Sauravji, can we meet tomorrow morning, 22/8/18 to morning
22/8/18.
or any other time which is suitable to you at your office? It's urgent, awaiting your reply. Again, mail sent on 23rd August. We seek your valuable appointment. Can we meet today? Kindly also arrange to clear my old overdue outstanding at the earliest. To clear my old overdue outstanding at the earliest. Tuesday, May 14, 2019, I have written in the email, the following checks are pending for amount rupees 56099 and 96760. This was the general reminder that we used to send the defendant company to release our payments.
What happened after the various reminders sent by you to the company, to the defendant company?
They used to make on account trickling payments, but after a while they refused my calls. They did not meet, so I was forced to issue them a IBC notice and also
IBC notice.
IBC notice under insolvency and bankruptcy code.
And I have also initiated the criminal proceedings under section 138.
I'm handing over to you a document. Kindly go through the same and let this court know what is this. Oh, sorry. The F bullet Judge Sahib. हाँ Judge Sahib bullet नहीं थे. अच्छा अच्छा ना. Sorry sir.
Yes, next.
This bunch of document is appearing as PD5 at pages 120 to 130 of the judge's brief of documents. 130. One 120 to 130.
Yes, what is the document?
This is the demand notice issued by the defendant company, issued by the plaintiff company to the defendant company under section IBC. It also has the postal receipt copy. The interest calculations, the ledgers, and the acknowledgement due card duly received by them, by the defendant company.
Have they, may I tender this and get it marked as tendered and exhibited as G collectively?
G collectively. Yes, next.
Has this notice been replied by the defendant company?
No.
Thereafter, have you received any payment from the defendant company?
No.
What is that you have filed this list for? This suit for?
To recover my principal amount along with interest.
Kindly, may I show him the affidavit of the plaint? The plaint.
Plaint. Repeat it.
Mr. Siroya, kindly let this court know as to who had issued instructions to file this suit.
I had instructed my advocate to file the suit.
Has this plaint been drafted as per your instructions?
Yes.
Kindly have a look at page 9 and 10 of the plaint and let this court know as to who has signed this.
This has been signed by me, Udit Siroya. I am the director of the plaintiff company.
Are the contents of this true and correct?
Yes.
Have the defendant company approached you for any settlement?
No.
Have you participated in a mediation? Oh, sorry. Have you approached for any mediation?
No.
Have you approached for mediation before the mediation cell?
Not necessary.
Very well. Very well. That is all that I have to show exhibit. So the defendant had filed a written statement, but thereafter they have not brought any document on record.
Affidavit of evidence.
Yes, Lord. Affidavit. Sorry, Lord. Affidavit had evidence seal. What is this affidavit that you have that has been handed over to you?
It is indicating the general course of business.
Has this affidavit been affirmed by you?
Yes.
Who has drafted this affidavit?
It has been drafted by my advocate on my instruction.
Can you find any signature on this affidavit?
Yes.
Kindly indicate where and at which page.
Page 8.
Are the contents of this affidavit true and correct?
Yes.
Have you read the affidavit before signing it?
Yes.
Dependent file return statement.
Yes, dependent has
So
filed a
return
written statement.
statement.
Though the contention in the written statement is with
Evidence.
evidence.
You not denied the return statement.
No, my lord, I have not. Not in this. Not in the affidavit. Not.
You have to deny.
Mr. Siroya, it is the case of the defendant that you have supplied the plaintiff company has supplied defective goods to the defendant for which they have suffered loss.
There have
Is it
been
correct?
Whether it is correct or not?
No.
It is also the stand of the defendant that by using the products that sent to you, their crops have been severely damaged. Sent by you, their crops were severely damaged.
Their crops were severely.
Is it correct?
No.
And that it is only because of you that they have suffered huge business loss?
No.
Have you ever received any communication with regards to the supplies made by you being defective?
No.
Or the quantity being less?
No.
Or any other grievance that they had with regards to your supplies?
No.
That's all.
That is all.
Actual, while preparing the affidavit,
Yes.
even in independent suit, I find due persons or not, it
Yes,
has to be taken as a not a fact that what is stated.
But since this is not an undefended, it's an ex parte.
No.
So I was
Even-
expecting
even
very well. I will
undefended
keep
or
this in mind.
even contested suit.
Yes, I
You
should.
have
I will.
to, you have to
We
deny.
should. We should. We should.
Deny that,
Definitely.
because that is in affidavit.
Yes,
And the court
absolutely.
has to consider that.
I'll keep this in mind when I'm doing the other matters. I'm obliged. I'm deeply obliged. We'll keep this matter for arguments, or should I file a notes of arguments and
Come with the written notes. I am found.
Yes. Yes.
Appearing for the plaintiff. Plaintiff witness is present. During his examination, documents were exhibited, being exhibit A to exhibit F.
G.
G. G. Full stop. Plaintiff evidence is closed. Counsel for the plaintiff submitted. She will not adduce any further evidence. Accordingly, evidence on the side of the plaintiff is closed. The affidavit of evidence filed by the plaintiff ऊपर आएगा. Affidavit of evidence filed by the plaintiff be kept with the record. Let the matter be fixed for argument on 10th July.
I'm deeply obliged.
Yes.
Deeply obliged.
My lord, may I have your lordship kindly to mention, my lord, for the extension of interim order, my lord, yesterday your lordship took up the matter, my lord, forgot to, my lord, mention it to your lordship that the interim order is still today. This is the matter, my lord, where Mr. Ray was there on the other side and I was being led by Mr. Shah, my lord, Mr. Jishnu Shah. My lord, the interim order is still today, my lord. Yesterday, my lord, the matter was taken up, but my lord, I forgot.
Yesterday no order was passed.
No, my lord, the extension of interim order was, my lord, not prayed for by us.
No, it might be in the order, that might be in the, it is not uploaded.
No, perhaps, my lord, it has not been, my lord, prayed by us, so that's why, my lord. Why not? Why not?
91 का है ये.
Yes. দুটোতেই থাকবে. Yesterday, perhaps your lordship just kept it on 15th of July, my lord.
857 में देखो. Hmm. 24. 8 कल का ऑर्डर पे नहीं, कल था ना, देखो कल का ऑर्डर देखो, रीटाइप हुआ, उसमें इंटरिम ऑर्डर है।
Perhaps, my lord, your lordship had just kept it on the next day because there was an appeal pending.
Numbering extended.
Oh, अच्छा.
Somebody mentioned that. है नहीं है चैम्बर में क्या? ओके, ये हमको दे दो, अगर नहीं होगा आई विल इंक्लूड दैट.
Malad, this is Malad, I was mentioning because it's still only till today, Malad. That's why.
Okay, I will because
Yes,
I will.
Malad.
Oh, my
No difficulty. That's the problem.
Okay, record and all. The matter is mentioned by the Learned Counsel for the petition and submits that the interim order
Till today.
Correct. In the submission made by the counsel for the petition, the interim order is extended. When that is
Malad, your lordship has fixed it. Both the matters, Malad, on 15th of July.
15th of July.
15 July. 15 July, my lord. 15 July is the name.
2025 or until further order.
I'm grateful. But I'm mentioning upon notice, Malad, to all the.
Malad, I think it may. No, yes. I'm appearing, Malad. And Malad, may I inquire what date your lordship has extended it till?
18th. 15th.
I didn't hear what date your lordship.
Mr. Mitra, it's still 18th.
18th.
Malad, it very well. The hearing date may be 16th also, Malad. I'm not very sure. So
15 or 16.
Grateful. I'm very well. Very well. Grateful.